So I'm sharing my screen, entire screen share. Right. Okay. So now I think my wallpaper is visible, right?
Yes.
Okay. So again, this is a disclaimer so that the entire presentation is copyright protected. So apart from that, today you have already covered all the basic concepts. So you guys have a working understanding of patents. You already know, I think we have already covered what is a patent, what kind of rights are offered by a patent, what is the duration of a patent, where all you get patent protection, what is the triple test that you need to get a patent granted: novelty, inventive step, industrial applicability. And after that, I think we went over section 3 also, what all is not an invention, even if it is patentable, what all is not allowed to get patented in India. I think we saw A to, I think O, right? K or O or P. Yeah, P. So P for parents, and that stands for traditional knowledge. And after that, I think we went over the procedure itself. What is a complete specification? What is a provisional specification? And then we saw what is the kind of processing which happens: publication, examination, and opposition. So this is pretty much the basic concepts covered. Okay. So today we will be understanding what happens based on this. So this was the rules of the game of cricket. And now we're going to see the actual cricket match itself, how the rules are applied. Okay. So today we'll be going over, you already know what is anticipation. So it's based on novelty, right? So today we'll see what are the exemptions to anticipation. Secondly, we'll be seeing what are the secrecy directions. Thirdly, we'll be seeing what are the different ways of applying for an application internationally. After that, we'll be seeing what is a compulsory license. And I think lastly, we'll be covering patents on addition. Okay. So of course, I cannot cover every single clause and provision in the act itself, but I am explaining every concept to its entirety. So just try and understand everything like a story. And next, after this, when you read the act, everything will fall into place. You'll be able to understand everything. Okay. So we'll go slowly. I'll take doubts at the end of each section. All right. So wait, somebody else is joining. Kaushik. Okay. Right. Cool. So I'll be taking doubts at the end of each section. All right. So firstly, we have already discussed what is anticipation. It's something very simple. Suppose I tell Uttam that tomorrow evening, Uttam, I'm coming to your house for dinner. Okay. So now Uttam will anticipate my arrival, right? He'll know that Vishnu is going to come for dinner tomorrow. So he'll prepare roti, pakoda, this, that, kachori, samosa. He'll keep it ready, right? And when I come to his house at around 9 o'clock, he won't be surprised because he has already anticipated my arrival, right? Same thing in a patent. If somebody has written about an invention in a research paper, or somebody has already invented something, or somebody has already shown it in public to everyone, or somebody has made a YouTube video about it, in which case all of us, the general public, the world itself, knows about this invention, right? So when I invent it tomorrow, the world already anticipates it, it already knows it exists. So that means the invention is not new. That means the invention has failed the test of novelty. You will not get a patent on it, right? But in certain cases there are exemptions offered to anticipation. So what are the exemptions? In what cases is anticipation allowed? Okay. So it allows it in 5 cases. First one, where there is a previous publication, and you'll see the terms and conditions. What are the terms and conditions for that? As in previous publication, as in where it has already come in some research paper. Secondly, where it has already been displayed in public, where there has been a previous display. Thirdly, where there has been a previous working, as in like where you have worked the invention in public. That means I've utilized it. I've put the bamboo copter on my head and I've flown around Bangalore and I've come back. So people have seen the invention working in public. Fourth one, where I've communicated the invention to the government, as in I've written it, I've made an application and I've submitted to the government. Okay. And lastly, where anything which happens after the priority date of the invention. Suppose I file the application today, then if I publish it in a research paper, then if I use it or if I display it, all that is totally cool, right? That's not anticipation because my filing has already been done. Cool. So the patent shall not be refused if it falls under the above 5 circumstances. So section 34 literally just says that if it falls under 29, 30, 31, 32, 33, then the patent will not be refused as lacking, as having anticipated, having been anticipated, right? So the first one, previous publication. Okay. So let's say your invention, you've made your invention, you've invented your bamboo copter, but somehow it was published in a patent application before you only. Like it was written in a research paper before you. Okay. So now we're going to see what are the exemptions. Suppose it has been written about, in what cases will it not be considered anticipation? So firstly, the first clause is kind of rubbish. So it says that it is not anticipated if the invention was published in another patent application dated before 1st Jan 1912. Okay. So how you remember this, I guess, is 1912 was when Titanic sank, and 1st January 1912 was when the Patents Act, the British era Patents Act, was made. Okay, so they had to put some kind of time limit, right? You can't check forever. So from 1912, they said anything before that we allow it, but anything after that we're not going to check for anticipation. We will check for anticipation. Okay, so if your invention, somebody had made an application before 1912, that's not considered anticipation. Okay, don't take it seriously. This will be an interview question mostly. They'll ask you what is the date mentioned in the Patents Act before which anticipation is not checked. So that is 1st Jan 1912. Okay, apart from that, forget that entirely. Next, let's say I've made an invention and somebody has published it in some research paper. Okay, for me, for it to not be considered anticipation, I have to prove. I'll take a laser pointer. The patentee must prove that the matter was stolen from the patentee and published without consent. As in, I should prove that Rahul has stolen that invention from me, the idea from me, and he has published it in that research paper without my consent. Okay. And next, I have to, after I learn of the publication, once I get to know that Rahul has published it, as soon as possible, immediately, I should file the application as soon as reasonably practicable. Okay. As soon as I find out the matter has been stolen and published somewhere fraudulently, I should, as soon as possible, file the application. Okay. If I do that, then it is not considered as anticipation. Okay. So any other patent applications filed for the same invention by illegitimate third parties and their usage of the invention without the consent of the patentee is also not anticipation. As in, let's say that I get into a fight with somebody else. Okay, I get into a fight with Satyanarayan. Okay, and Satyanarayan steals my patent and he files an application fraudulently. Okay, so if I file my application later on and then I find out that Satyanarayan had cheated me and he has filed it, in which case Satyanarayan's application will not be anticipation for me. Okay, so to summarize the whole section, if anything is done without your consent, if the invention was stolen from you and published, then it is not anticipation for you. Okay, you are still given a free check. That's it. Okay, and then the 1912, just remember it. Only from 1912, 1st Jan 1912, you'll check all the applications to see for anticipation. Simple. So previous publication is done. Now previous display, where it has been displayed in public. Let's say my bamboo copter was placed in some kind of exhibition and thousands of people saw it. Okay, so where all is it? Not anticipation. If it was displayed or used at an industrial exhibition, which has been notified by the central government in the official gazette. Okay, so the central government, what does it do? It likes to promote technology, right? R&D. So it usually calls for these expos and all to introduce and bring investors, to call people to promote scientists and technological developments. So if it is a industrial expo which has been notified in the official gazette, authorized by the central government, in which case if your invention is displayed over there, then it is exempted. Okay, next, any publication of any details of your invention in consequences of that display at the industrial exhibition, that is also exempted. Let's say in that display, in that once it's displayed in the expo, they publish a brochure or they publish some kind of manual about your invention, even that is exempted. Okay, then use of the invention at or after the industrial exhibition without the consent of the patentee. Let's say without your consent, somebody has taken that bamboo copter outside the expo and they've flown it around. In that case also, it is not anticipation because it was done without your authorization, your consent. Okay, it was done fraudulently, in which case it is not anticipation. And lastly, description of the invention in a paper read before a learned society. Okay, let's say there are a group of professors or scientists, or like Albert Einstein, he writes a paper and he goes and he reads it, he presents it to other scientists. That is not anticipation. Okay, or published with his consent in the transactions of such a society. So again, this is to promote what? To promote science, right? To promote R&D, to invite other scientists also to come and see your invention. So even this is exempted. Okay, if any of these four things have happened, okay, where it has been displayed at an industrial expo or any information regarding that has been displayed, so in which case you will have to file the application within 12 months after that happens. So application for the patent should be filed within 12 months after the use, display, reading, publication at the exhibition or the learned society. Okay, so even if it happens in these four and you wait for 2 years, then you're screwed. Okay, it will fall into the public domain, so you'll have to do it within 12 months. In this case, it is as soon as reasonably practicable. In this case, it is within 12 months. Cool. So previous publication is over, previous display is over. Now we'll see previous working, where it has been utilized in public. Very simple. If you utilize it only for the purpose of testing, so if the invention was publicly worked by the patentee for the purpose of reasonable trial, that is testing and R&D, then it had to be reasonably necessary that you had to do it in the public and not in some secret lab. So if you can prove that it was necessary to show it in public, then fine, it is not considered as anticipation. Even in this case, the application should be filed within 12 months after the public working. Okay, suppose I test it in the public today and I wait for 3 years, then it is anticipated. Cool. I think there was a case also. Padma ma'am told us about IIT students. So they invented something and they demonstrated it outside main building or something, and they made a YouTube video about it. They published it, and after like 1.5 years, they went for a patent. It was not possible to get it because it was on YouTube, first of all, and it was published with their consent only. It was not stolen and published. So it fails the exemption there. And secondly, 12 months had passed also, right? And they were not doing it for testing, they were doing it to show off the invention. So pretty much kind of screwed. So I think even in Three Idiots, right, they take the drone and they fly it around. So even that is called as public working. So if Amir Khan did that in Three Idiots, he has to file the application within 12 months. Cool. So just the last two, communication to government, as in, let's say you file your application, right? Can the examiner say your application itself is anticipation? No. So communication of the invention to the government, as in when you submit your application to the patent office or any person authorized, as in when you submit it to the controller or the examiner, and by the government you submit it for what? For them to investigate the invention, right? When they do, for them to do the examination. So any communication to the government of your invention for what? For the legal purposes of getting a patent, that is also exempted from anticipation. Okay. And then lastly, use after the priority date. So once you file your patent, your priority date is established. Okay. Let's say I file the patent today, December 19th. Okay. And then tomorrow I use it in public or I publish it. All that is allowed. Okay. So use and publication of the invention after the date of filing is allowed. Okay. And in case of an international application, I'll explain to you everything about international application today. So even after filing the international application, use and publication of the invention after the earliest filing of the international application is allowed. Okay. Why I said earliest filing is, I already told you patent rights are territorial. So I'll have to file it in different countries, India, then Africa, then Australia. In that case, you will see the earliest filing. Okay, the country you file the earliest in. Cool. I think we are done with anticipation, exemptions to anticipation. I think it's very clear. Any doubts? Cool. It was actually very well explained. So I'll also be proceeding. Secrecy directions. Okay. Let's say I invent something top secret, as in like something which the country does not want the public to get to know. Okay. Let's say I invent a new kind of atom bomb. Okay. Or a missile. Let's say I invented the BrahMos missile tomorrow. Do you think the government will give me a patent on a BrahMos missile? Or let's say I invent a new kind of machine gun, new kind of AK-47. So all these kind of things, anything which is related to the defense of India, right? Anything related to the security of India, all this, the government will never allow for it to become a patent. Okay. Firstly, because you don't want the public to have guns and missiles. Secondly, you don't want that kind of information reaching the terrorists and all, because every patent is in the public domain. You can go online, go to the patent website, and you can download the details of every patent, right? So they don't want this kind of technology reaching the public or terrorists. Okay. So in which case, suppose you develop something like this, secrecy directions are imposed. Okay. For anything defense related. So in this case, if you file something which the controller feels that it is slightly related to some kind of defense, then controller passes a secrecy direction. In this case, the application is maintained secret. Okay. What that means is the invention is not published. So what I told you, once you file your application, suppose you file the complete specifications within 12 months, then at the end of 18 months, your application will be published, as in the whole public will get to see it on the patent website, right? And then people can come see it, oppose it, all this. So now if it is a secret invention and the controller has imposed a secrecy direction, the invention is not published. Okay. But the processing will still continue. The processing continues till the stage of grant. Okay. So that means the examination will happen. The examiner will check for novelty, inventive step, industrial applicability, everything. But it will go till the grant, but the grant will never happen. Okay. Your patent will never be granted as long as your technology is considered as top secret. Okay. Once secrecy directions are revoked, and then all the extensions to, then what happens, like basically what you'll tell is, I didn't have time to comply with all the requirements of the patent act, because the controller will tell, you should have complied with this in 6 months, you should have done this in 3 months, you have not done it, so you have failed the deadline. So once the secrecy directions are revoked, then you'll get extensions to all the prescribed time limits for any actions involved in the processing. Okay. So let's say your secrecy was for 8 months, then all your time limits will get extended by 8 months. Okay. I'm not 100% sure, but I think even the duration of protection might be increased by 8 months. Okay. I'm not fully sure on this. I don't think it's possible, but every prescribed time limit can be extended for the duration of the secrecy. Okay. I'll check and get back to you on that. Cool. So I've put in a few points from the section itself. So if the controller feels that the invention relates to any class notified by the central government as relevant for defense purposes, then the publication of the application is prohibited. Simple. Application is submitted to the central government for consideration. Then it is sent to DRDO, or maybe it's sent to some other top secret ministry that we don't know about, RAW, or maybe the Intelligence Bureau, and then they go through it. Okay. And then if the central government finds the application not harmful to the defense of India, controller will revoke the secrecy direction. Okay. Once the secrecy is revoked, then the application can be published, the patent can be granted. So let's say the controller has not found that it relates to the defense of India and he passes it. He doesn't check it. If the central government on its own comes to know of any invention that is relevant for defense purposes, it will notify the controller to issue secrecy directions. And once the controller has been notified and he issues it, the application becomes secret now. Okay. Every 6 months or on request of the applicant, and you can't request every week, it'll have to be once every 6 months only, secrecy directions will be reviewed by the central government to check if the invention is still relevant for defense purposes. So let's say secrecy has been imposed on my bamboo copter. So government of India is telling me that terrorists will put on the bamboo copter and fly to India. They'll cross the Wagah border. Okay. So it's not allowed. So secrecy has been imposed. My patent is not being granted. So every 6 months, I can ask the government to review it. Please go through it. Like, don't do this to me. And I'll ask the government to reconsider. Okay. Apart from that, so one more thing is uh, secrecy will be reviewed. Apart from that, yeah, basically the decision of every review will have to be communicated back to me. Even if the government refuses to revoke the secrecy, the reason for that also has to be communicated to me. Okay. And in case the central government feels that I'm being unduly harmed, as in like because of the patent not being granted, because me not being able to sell the bamboo copter, I'm being harmed, then the central government might give me some kind of compensation. Okay. Some kind of just and reasonable adequate compensation. Okay. Cool. So that brings us to the end of secrecy. Okay. Any doubts in secrecy? Cool. I think we are going very slow and steady. And now we start the tough part. Okay. Everybody drop everything and pay attention. This information about international application, I can tell you for a fact, no YouTube video or no human can explain this because nobody knows this properly. And I have worked on international applications at TVS, so I have a pretty reasonable working idea of what it is. And I'll explain it to you as easy as possible. Okay. It's a little complicated. Just pay attention. So to file applications abroad. Okay. So the secrecy provisions are not complete. So the secrecy provisions start from 35 and they go till 43. Okay. So now we are at section 39. Okay. So we finished 35 to 38 and now 39. Okay. So now so suppose you have to file an application abroad, any form of application you want to file internationally. Suppose I want to file it in Africa or US. So all persons residing in India, we're not talking about Indian nationals or citizens or Indian domicile people. Okay. Any person who resides in India, let's say it's an American, but he has resided in India. He's been residing for 2 years, in which case he also needs permission. Okay. So all persons residing in India, foreigners included, can file an application outside India only if the applicant has a written permit. You need to get something called as a foreign filing license. Okay. So this you need to fill a form called Form 25. So we'll study all the forms also later on another day. You have 30 forms, Form 1 to Form 30. So based on each form has its own function and purpose. Form number 25 is to get a foreign filing license. Okay. Only when you get this, you can file for an application abroad. Or the applicant has filed an application for the same invention in India first, and 6 weeks have passed before the application is made abroad. So you'll have to file the application in India first for bamboo copter, wait for 6 weeks, and only after the 6 weeks have expired, you can file the application abroad. Okay. So very simple. They always want you to file the application first in India, or they want you to take permission from the Indian Patent Office. So either you can take the permission and get the foreign filing license, or they want you to file it in India first and wait for 6 weeks and only then make the application abroad. Okay, this is the basic concept. And now this basic concept is applied differently for PCT and Paris Convention. Okay, I'll explain both of them very slowly. So, firstly, for you to file abroad, of course, no secrecy has to exist, right? I can't file an application for an AK-47 and then go take it to Africa and Pakistan and file it there, right? So, secrecy should not be imposed. That's another requirement. Then, lastly, violation of the secrecy direction under section 35 or this foreign application procedure. Suppose you violate this procedure and you file it in Africa without taking permission or waiting 6 weeks, will result in your Indian application being deemed abandoned, or if your patent has been granted, it will be revoked. Okay. Let's say your patent has been granted and then later on somebody opposes it. They say that, oh, look at this guy. Vishnu did not even fill Form 25 and he had applied in Africa without taking the requisite permission. In which case, your patent will be revoked. Okay. Because you have not complied with section 35 or 39. Cool. So this is the
Vishnu,
yeah, one second. So this is the permission that you need to apply abroad. Okay. So this concept we will revisit again once we learn PCT and Paris. Any doubts? Yeah.
so Vishnu, what is the justification provided behind the reason for the delay of 6 weeks for filing an application abroad?
So this is again an arbitrary number. Their only intention is so that they are informed of whatever you do. Okay, the Indian Patent Office always wants to know where all your patents have been filed. I'll explain this again very clearly. So just listen to it like a story now. I'll explain what the Patent Office wants. Okay. So what did I tell you guys last time? I told you guys that patents are territorial in nature, right? That means that suppose I have a patent, okay, and I want to file an application, and let's say I file the application in India, okay. So the patent is protected only within India. So somebody in Pakistan can make the same robot and use it for delivery, okay. They'll use it for something. So I can't stop them, okay. So for me to stop it in some other country, let's say I want to stop the making of this robot in the US, I have to file the same application in the US, okay. And let's say I find out that, oh, London also I want protection, I'll have to file the application again in London, okay, in UK. Then I want to file the same application again in Pakistan. Then I want to file the same in China, and again I want to file the same again in South Africa, okay. So all these applications are protecting the same invention, okay. That means all these patents are called as a patent family, okay. They all belong to the patent family of this robot, okay. So patent rights are territorial in nature. That means it's valid only within the territory of a country. Next, the same invention must be patented separately in different countries. And lastly, the applications all have the same priority date and duration of protection. Okay. So you might think very smart that, oh, I'll get it in India from 2000 to 2020. Then in 2019, I'll go to US and I'll take it till 2039. Then I'll go in 2038 to UK and I'll take it till 2058. No. Once you file the Indian application, all of them have to be filed within a certain time limit. I'll explain it, and all of them will expire in the same time. Okay, the patent family is born together, and the patent family dies together. Okay, because it's a family. Okay, cool. So moving on. So when you file an application internationally, okay, suppose I want protection in a large number of countries, so I can do it in two ways. So initially, long back in 1883, they created something called as the Paris Convention. Okay, and then more recently in 1970, they formed the Patent Cooperation Treaty. So Patent Cooperation Treaty is more like an advanced version of the Paris Convention. It's like an updated software patch, the Paris Convention. Okay, like as in all the things that lacked in the Paris Convention have been brought here, but both exist even today. Okay, so you can apply an international application under the Paris Convention even today, and you can also apply under the Patent Cooperation Treaty even today. Both have their own differences. Okay, and you'll be able to see which is better. Cool. So under the Paris Convention is called as a convention application, and under the PCT it's called as a PCT application. So in the Patents Act, whenever you read, you'll constantly run into the term convention application, and you'll run into the term international application for PCT application. Okay. So this is what they mean. When I say convention, it means I've gone under Paris Convention. If I say PCT, it means I've gone into the PCT. Okay. And India has joined the Paris Convention PCT very late, only in 7th September 1998 after the TRIPS agreement. But again, TRIPS is a little more advanced. We'll see it later. Cool. So India is a member to both the conventions. That means India can use either of these. So you as an Indian patent attorney can apply either through Paris or through PCT. Okay. Cool. So first we'll see Paris, then we'll take PCT. Okay. Any doubts till here? Cool. I'll go very slowly now. Try and follow along. Okay. So Paris Convention is a little older, okay? It's administered by WIPO only. So WIPO only administers Paris Convention. It only administers PCT. And I'll explain Budapest Treaty also, even that is administered by WIPO. So WIPO is the World Intellectual Property Organization. That's like the world's patent office, okay? It's headquartered in Switzerland. Cool. So under the Paris Convention, you get two things, okay? The Paris Convention guarantees two things. Firstly, it guarantees national treatment. And secondly, it guarantees common priority date, okay? So national treatment is something very simple. Let's say I go to US, okay? If the US government gives me the same rights as it gives to another US citizen, that means it has given me national treatment. So a foreign applicant receives the same treatment as a national citizen, as in the same protection, the same remedies, the same status, and the same rights. So all the members of the Paris Convention, so it has around 179 member parties, right? So even if you go to any country under the Paris Convention, it will give you the same rights that it gives to its own citizens. Okay. So that means if you file a patent application in Africa, and let's say South Africa is a member of the Paris Convention, all the rights which are given to a South African will also be given to you as an Indian. Okay. So that's what the convention did. It brought everyone together and it ensured that everyone gets the same treatment. Next, it got a common priority right. That means that an applicant can use the filing date of the application in one member country as the effective filing date of the application in any other member countries if filed within a window of 12 months. Okay. Let's say Jan 1st, 2023, I filed the application in Pakistan. Okay. I can use the same date when I file it in Indonesia in March. Okay, then I can use the same Jan 1st of Pakistan in Africa when I file it in August, and I can use that same date in India when I file it in November. Okay, but all of this has to happen within a window of 12 months. Okay, so I think you've understood what is the wonderful thing the Paris Convention brought. It brought two things. First, it guaranteed the same rights that a citizen will get in that country, and secondly, it guaranteed a common priority date. So now what is the advantage? The advantage is now nobody can infringe your like suppose I file the application, you get a larger window of claiming your priority now. Okay, I can claim the same priority within multiple countries now. Okay, that's what the Paris Convention guaranteed. And Paris Convention is actually landmark because it granted these rights not just to patents, it got it for trademark, copyright, and even designs. Okay, so it's like a landmark agreement which was signed in 1883. Cool. So application will be processed and granted in accordance with national law. What it means is, even though you're giving national treatment, and even though you have the same common priority, it does not guarantee that you'll get a patent in every country. Okay, individually that patent office has to still examine and grant you the patent. Okay, so Paris Convention only gives you the same starting line, but you getting your patent granted in that country is up to you. Okay, the Paris Convention does not force that, oh, Pakistan has granted the patent, that means India has to grant, or India has granted, so Africa has to grant. No, it only says that India has to give the same treatment to the other citizen, and it also has to allow the common priority if it is within 12 months. Okay, so the application will still be independently processed by each national patent office. Simple. So PCT is the same as this, but it's a little more advanced. Okay, we will see it, but first an example. So first, I go to South Africa and I file my application on 1st Jan 2022. Okay. So assume that all these countries are part of the Paris Convention. Okay. So South Africa filed it on 1st Jan 2022. And my priority date is the date of filing, which is 1st Jan 2022. Cool. Next, I file the same application in the United Kingdom on 3rd March 2022. Okay. So is this allowed under the Paris Convention? Yes. Okay. And it will draw the same priority date as the earliest filing, which is 1st Jan 2022. Same priority date. Next, I file the same application in India. Okay. Since India is also a member now, even though it was filed on 9th October, it will have the same priority. It is allowed under the Paris Convention. Okay. Next, I filed the convention application in the US on 10th Jan 2023. Okay. Do you think this is allowed? The answer is no, because it has not been filed within a window of 12 months. Okay. So I think this is the end of the Paris Convention. Any doubts?
Yeah,
Somebody?
so so for America, will they abandon this application?
So what will happen in America is they won't abandon your application. They will take your application and they will tell you it has been anticipated. Okay.
Okay.
It will be treated as a separate application. You will not be given a common priority. That's all.
Okay. So means the person won't be able to get the
So
patent in America.
yeah, he won't, because his priority date will be 10th Jan 2023. During the examination, the examiner will tell you have no novelty. It has already been anticipated on 1st Jan. Okay. Cool. That's it. Cool. Next, we come to PCT. Okay, this is much newer, 1970. Only 157 members are there. That was 179. Again, this is headed by WIPO. Even PCT and Paris exists today. You can use both. Okay, so that was 12 months, right? PCT also gives you both the benefits. It gives you national. Secondly, with respect to the common priority, PCT does something wonderful. Okay, PCT gives you a common priority right where an applicant can use the filing date of the PCT application in one member country as the effective filing date of the application in any other member country under the Paris Convention if filed within a window of 30/31 months. Okay. So the month window, time window is 30/31 months. Okay. So the PCT, if you go through the treaty, it says a minimum of 30 months. Okay. So a lot of countries give 30 months and some countries like India give 31 months. So it's 30/31 months. You'll have to see which country it is and then get to know what is the window. Okay. So what is the difference now? So PCT offers a larger time window and also simplifies the procedure with a single PCT application. So in the conventional application, you will have to go individually to each country. Little more. So it provides for international publication of the application, international search, international preliminary examination. before entering the national phase. Okay, I'll explain it. Somebody is chatting, sending a message on the chat. I can't read the chat, so just unmute and ask me a doubt. Okay, not
I
now.
think there is network issue, right?
Is there a network?
I think Vishnu, we missed in between just a
Right,
few seconds back. You were not audible for a
Oh, right.
long
I'm sorry.
period
How
of
much did you
time.
guys miss? Okay.
I think after 30 to 31 months,
I'm
we
sorry.
just
I'm
missed
sorry.
the
Okay.
entire
So was the
audio.
connection fine till now, or has this been happening repeatedly?
No, no, just this time it happened.
It
Okay.
happened
Okay. Wait.
twice or thrice, but
Sorry.
yeah.
Sorry. Wait. I'm just okay. Okay. I think I'm connected to the. I'll just connect to the closer one. Okay. Okay. If you miss anything, please tell me again. Cool. So I said what I wanted to say was cool. I'll just repeat that. So what I said was it's the same as Paris Convention, but here you get a larger time window of 30/31 months. Okay. So so what does PCT do? Firstly, it offers a larger time window. And secondly, it also simplifies the procedure with a single PCT application. So in Paris Convention, each country you had to go separately file a separate convention application. But now you can just file a single PCT, and then it happens like a checklist where you just have to tick whichever countries you want, and after that you'll still have to individually get it processed independently by each patent office, but you can still utilize the same PCT application. Okay, so it simplifies the procedure. And lastly, it provides for international publication, international search, and international preliminary examination before entering the national phase. So national phase is when you have to individually enter the countries. Okay, so I'll give you an example of how the PCT works. Firstly, the procedure. Okay, so now that I explained to you what is this, what is international publication, what is international search, and what is preliminary examination. Cool. So apart from that, PCT is the same as Paris. The difference is you get a larger time window of 30/31 months. Did you guys hear when I said why it is 30/31, where the PCT says it's a minimum of 30 months?
Yes,
Was that
some countries provide 30 months
exactly?
window, and some countries like India provide 31 months also.
Exactly. Okay. So majority give 31. It's just some faltu countries which give 30. I guess EU gives 30. I think. Let's see.
Vishnu, just one doubt here.
Go on.
This simplification of procedure that
Hmm.
you just mentioned.
Hmm.
So, is it like there is a single application with choice of multiple countries,
Ah.
and you have to separately file those that one particular application in different countries?
So what it means is, so in the PCT only, you have to submit your diagram, your complete specifications, your details, everything. Okay. So whenever you file Paris or PCT application, there's no provisional specs. Okay. You can't tell, oh, I'm still developing my invention. After 12 months, I'll file complete. No. When you file it, your complete has to be done. Okay. So in which case, in your PCT, all the diagrams, all the details, all the claims, all that can directly be imported for your national application. You don't have to file anything separately. You can just claim it from your PCT application. So it just simplifies the procedure. Cool. It's not very relevant for the parent agent exam. Maybe once you start working, it might be relevant, but just listen to it like a story. Cool. I'll explain it again. So the procedure is as follows. Okay. So first, you file the PCT application. It's called as a PCT application only in the regional office, as in your country's national office. So what is it in India? Delhi, right? So the Delhi parent office, or you can directly file it as WIPO in the International Bureau. That's in Geneva, Switzerland. Okay. And after this, three things happen. Okay. Firstly, international search. So this is something which is mandatory. Whenever you file the PCT application, an international search automatically happens, where the PCT, the office that you file it with, when you file the application, you'll have to select an international searching authority. Okay. So any patent office in the world, okay, the Japanese patent office, the Indian patent office, the European patent office, the US patent office, any patent office can be selected as the international searching authority. Okay, to perform an international search, as in they will check for novelty, inventive step, industrial application, all this. Okay, they will do a global search for you. Okay, and why they do this is just to give you a written opinion. So the international search authority gives an international search report, ISR. So this is what we worked on in TVS during our internship. That gives an opinion on the potential patentability of the invention. Okay, so what the examiner will do later on for you, these people do it preemptively for you. Okay, so they search for you, they check your novelty, the industrial application, and they give you a report and they give you an opinion based on what they think. Okay, is it patentable, is it not patentable, and they list out all the matching documents, all the research papers, all the other matching inventions. Okay, and they even give recommendations. Suppose you go to the European patent office as the search authority, they even give recommendations what could be changed. They'll correct the grammar, the clerical mistakes, everything is corrected. So this is like a correction phase where before you submit your exam, you give it to your buddy bhai and he gives you as a draft correction, right? So who's sending these messages? Oh, oh, you've raised your hands. You don't have to raise hands. I'll take doubts at the end. Okay. So very simple. So the search authority, wait, I'll take the routes. So search authority just does a examination, as in it does a preliminary search for you, and this is mandatory under the PCT. Okay, so this you cannot avoid. When you file a PCT, the search will always happen. Okay, so you will have to select any patent office. I've given you an example, so wait for it. Wait, I'll take doubts. Wait. So I've given an example. You'll understand it clearly after that. So once the search happens, there is an international publication. How in India, the application is published after 18 months. Same way, there's an international publication on the WIPO global website. Okay. So after 18 months of the priority date of the application, that is the earliest filing date, the application is published in the global PCT database on WIPO's website. Okay. So it's published as in anyone can see it now. Cool. So the publication is also mandatory. Once you file a PCT, it has to be published. Cool. This can never happen in the Paris Convention because firstly, it has to happen within 12 months. Here only we have the 31 months time period, right? So 18 months is not relevant in Paris Convention. So there's no publication under Paris Convention, but all this is there here. You have the international first, then you have the international publication. Cool. And then the last thing, you have something called as an international preliminary examination. Okay. Just one second. Just a second. Cool. So how the examination happens in the national application also, they do a preliminary examination. Okay. So what this means is once your search has happened and then the ISR report has come, the international search report has been given to you by the International Searching Authority. It gives you all the recommendations. It tells you that novelty is not correct, inventor step is not there, claim number 3 is bad, 4 is bad. After this, you can amend your PCT application. So your PCT application may be amended to match the recommendation and opinion of the search report. Okay.
Vishnu, your network is still having some issues. I think
What is the
your
issue
voice
now?
is breaking.
Cool,
a
cool.
bit.
At what point did it break? At what point did it break?
It's breaking here and there now, not in a.
Do you think it's a
Not in a
microphone
go,
issue or is it a internet issue?
I
What do you
don't.
think?
I'm not sure, but I think
I
there's
think
some
it's
issue out here.
because
1
at
second.
some point only it is going.
Okay. I apologize. If it happens one more time, I'll switch my network to my hotspot. Okay. I'm really sorry for that. One more time it happens, please stop me and tell me. Okay. Cool. So what I was saying was should not happen now. Okay. Let's see. Cool. Cool. So the preliminary examination, like I told you, once the search report has come from the International Searching Authority, you can amend your PCT application. Okay. You can make all the changes that they've said. PCT application may be amended to match the recommendations of the written opinion of the search report. And again, you can submit it for examination. Okay. Now the application may be submitted again for international preliminary examination. Again, you can select any patent office, European, Japanese, Indian, everything. So that's called as the International Preliminary Examination Authority. Okay. So this is completely not mandatory. It's purely optional. If you want it, you can get it done. Okay. Then the IPEA, the International Preliminary Examination Authority, provides a preliminary examination report, like how the international search report, an examination report is made, and that gives a final opinion on the patentability of the invention. It will finally tell you, is it patentable or not after you have made the changes. Cool. And after this, whether this happens or not, whether the examination you have done or not, irrelevant, it's not mandatory. Applicants can go for the national phase entries within 30 or 31 months after filing. Okay. National phase as in when you apply for it in the individual countries. Cool. So I'll give you an example and I'll take doubts right after this. Cool. So there is a PCT application filed. Okay. The PCT application has been filed in the Indian Patent Office in Delhi on 1st Jan 2020. Cool. And in that PCT application, I have to select what is the International Searching Authority. So I select the International Search Authority as the European Patent Office. I don't have to select India. Okay. I can select any patent office based on where my invention is going to be marketed later on. Cool. Then on 1st December 2020, so 1st Jan is when the application is filed. That means my priority date is 1st Jan, right? So on 1st December 2020, the European Patent Office issues an international search report with a written opinion. So it tells me what is my novelty, what is the inventive step, what all other documents are clashing, all the rubbish recommendations it will give me. Cool. And then on 1st July 2021, 6 months after this, as in like totally 18 months have passed from 1st Jan. 18 months have passed. So it is 1st July 2021. My application is automatically published on the WIPO Global PCT database. Okay. 18 months from the filing. Cool. After this, on 1st December 2021, Okay, as in one year after this search report has come, the applicant makes amendments to his PCT application. He changes a few things. He changes a claim, he adds a new claim, he removes something, he makes amendments. After that, on 1st March 2022, again 2 more months after that, the applicant files for international preliminary examination. And here I can select another preliminary examination authority. And I select the Japanese Patent Office as the international preliminary examination authority. Now that I've amended it, I want them to check it again. So I file an examination. Okay. And now on 1st August 2022, almost 2 years, more than 2 years after the filing of the application, the Japanese Patent Office issues the preliminary examination report. Okay. So what I want you guys to clearly understand here is all the steps from here. Once the publication has happened, all this is optional. Okay. All this is not mandatory. So you just need to understand search report, then publication, then preliminary examination. Okay. Just one more thing now. So once the thing happens, so let's say on 1st Jan, the application has been filed. Okay. And then 1st December, the European Patent Office issues the search report with the written opinion. And then 1st July, the application has been published after 18 months. Cool. Now the person can proceed for national phase filing in different countries within 30 or 31 months of the priority date. So 30 or 31 months from Jan 1st is 1st July 2022. So within this, I can enter any country. Suppose I go on 1st of September or November of 2022, and it's after the 31 months, then my application cannot be entertained under the PCT, Patent Cooperation Treaty. It will be deemed as anticipated, right? Because I can't claim the older priority date. I cannot claim Jan 1st as my priority date. Even if I go on 1st, 30th June to South Africa, I can claim 1st Jan as my filing date. Okay, so that's the advantage of the PCT. So what I want you guys to know is, let's say the search report tells my invention is garbage. Okay, it tells it's the most rubbish invention I've made. Okay, let's say I try to invent, I file an application for polka dots on underwear. Okay, that's my invention. And the ISR, I file a PCT application. The ISR report says that it's the most rubbish invention. There is no novelty, no inventive step, nothing. You'll not get the patent. And then my application is also published after 18 months. Okay, both the search report and then even the subsequent preliminary examination report are not binding or have any effect on the future of the patent application. Even if it tells me that my invention is complete garbage, that does not affect what might happen in the national phase. Who knows? Maybe I might get my patent in Pakistan, right? But the search report is not binding. That's all. It's just like an opinion. Just like when you go to a lawyer for an informal opinion. Cool. So the search report only gives you an opinion on the patentability of your invention. It's not binding. Cool. That's it. Any doubts? Yeah. Was my voice clear? Did it stop, Uttam? Now, was there any break?
No, the voice was perfect. Just one clarification. When that in this search report, when the opinion is given by the patent office, does it substantiate it with the issues that it has raised, or it just is just observation is made?
Cool. So this depends on the patent office. Okay. European Patent Office gives you like a PhD thesis. It gives you details. Proper. First, it tells you novelty is missing in claim number 4, and then it explains why it is not there. Then it will list out all the previous documents that are there, and it will tell you what is the similarity. It gives you the best written opinion. Okay. So even in TVS, when they go for all the very great, like the most complex inventions, the inventions which are going to be very commercially valuable, they go for the EPO. Okay. But Indian Patent Office, you know, right, what kind of people we have in our governments. So they give you a very rubbish international search report. Normally, it's like hardly 2 or 3 pages, and they just tell you novelty is not there, inventive step is not there. You go find out what's missing, what needs to be changed. Okay. So Indian Patent Office does not give you a very good search report. I know it's very unfair of me to say as an Indian, but honestly, the quality is not there. And the advantage, the offset is Indian Patent Office is very cheap. So you'll have to pay a different fees. When you select EPO, you'll have to pay a larger fee. When you select the Indian Patent Office, the fee is very less. Okay. So that's about it. Cool. Any other doubts? Perfect. What else is there? So a little bit of, I think a few details. Cool. So PCT application is filed in the Indian Patent Office on 1st Jan 2020. Cool. So in this PCT application, I can select what all countries. It will have a list of all the 157 member countries. Okay. So here I'll just have to put tick. Yes, I want to enter India. I want to enter UK. I will be entering China, US, Pakistan. No, I don't want to go into that country. South Africa. No, I don't want to go to that country. So it's like a checklist. Okay. And after that, you can subsequently use the same PCT application, all the specifications when you enter the national phase. Cool. So time till 1st July 2022, as in 30/31 months to make national phase applications in the selected countries. Okay. larger time window, allowing for better market research and business strategy before entering a country. So let's say I've invented a new kind of car, okay, new kind of motorcycle engine. So I want to manufacture it in Brazil and sell it in Brazil. But I need to find investors, I need to find a factory there, I need to find customers there, I need to find showroom people there, franchisees there. So I have more time to do all this market research now, right? So that's the advantage of the PCT. You get more time to do all this research before deciding whether you want to go to the country or not. Okay. Under the Paris Convention, you have only 12 months. So within 12 months, it's not possible to do such an elaborate research. But here you have 31 months, almost 2.5 years, right? So that's the advantage of the PCT. Cool. So that's about it for Paris and PCT. Any doubts? All right. So now I'm going to explain something very obscure and little complex. And now, go on.
So for filing the international applications, either we have to go through PCT or that convention application.
Paris Convention application. Yes.
Only these two ways are there, right?
Only these two ways. Yes. No other way. As in like you can go for an application, but you cannot claim priority, common priority, or national treatment. Okay, that's the issue.
And both these are available in the form number 25.
Wait. I'll explain it now. Good question. So now that you have heard of PCT and Paris Convention, how do you do it in India? Okay, because if you remember correctly, I already told you about section 39. What did it say? It said that you need to have permission to file international application. Either you need to have the foreign filing license under form 25. Fantastic doubt that you asked, perfectly in time. Or secondly, the application should have been filed in India and 6 weeks should have passed, right? So this we've already seen. Now we'll see how this applies now. Okay. So what does India want? India does not want you to file any application in any country without informing them. So they should always know that you've filed an application abroad. Okay. So with regards to this, what they expect you to do is, first, this is how you file an international application in India. Okay. Suppose you have to file any application that you want to file in different countries. This is how you do it. This is the procedure. First, on Jan 1st, 2023, you file an Indian application in India. Okay. Very simple. No PCT, nothing. No Paris Convention, rubbish, nothing. Always you have to file the Indian application first on 1st Jan 2023. Okay. So now the priority date is what? 1st Jan 2023. Simple. Now you have two options. Either you can file Form 25 and get a foreign filing license, or very simple, you just have to wait for 6 weeks. Okay. In case you get the foreign filing license, you don't even have to file the Indian application, but don't worry about it. It's too complex. Okay. Don't go for it. And pretty much for the patent office to get back to you, it will take 6 weeks. You know, right, how our government offices work. So the first option is pretty much faltu, unless you're trying to pull off the greatest money heist in world history and you're trying something super advanced. Don't go for it. So either you can get a foreign filing license under Form 25 or file the Indian application, wait for 6 weeks until what is 6 weeks after this? Around 7th Feb 2023. Okay. After that, on 1st April, so definitely 6 weeks have passed, right? So first you file the Indian application, which has a priority date of 1st Jan. Next, on 1st April 2023, you file the international application. You can either file a PCT application or a Paris Convention application. Okay. So either you can file it in a different country, or you can file the PCT application in Geneva, or you can file it in India. One of them, either the Paris or the PCT. Okay. So now you file it on 1st Jan 2023. What is the priority date? The priority date is again 1st Jan 2023, because it is drawing the priority from your earliest application filed, which was filed on 1st Jan. Cool. Very simple. Now it gets a little more complex. So now that I filed the application internationally, so if it is a Paris Convention application, now 1st Jan is the priority date, right? So you get 12 months of time now. So 1st Jan 2024 is the time window now. So you have time till 1st Jan 2024 to apply to other countries. Suppose you go for a PCT application, then from 1st Jan you have 30/31 months. That means you have time till 1st June 2025 to apply to other countries. The 1st June if it's 30 months, 1st July if it is 31 months. Cool. Till here it is clear. Cool. Now it gets a little more complex. So till here it's clear, right? 1st Jan you have the priority date of the Indian application. When you file the international application under Paris or PCT, it draws the same priority date now. Now I want to file the application in the US now. Okay. So 1st December 2023, I file a national application in the US. Okay. As in the US, I want to file the application now. Cool. So what's the issue now? There's no issue, because the priority date of this US application is again 1st Jan 2023, because it draws the priority of the PCT or the Paris Convention application, which is drawing it from the earliest filing date, which is again 1st Jan 2023. So very simple. Suppose you have followed Paris Convention or PCT, any application that you file under these two conventions or the treaty will take the priority date of the earliest filed application. Okay, so this is how you file it in India. First, you file it in India, then you file the international application, then you go into the different countries. Okay, the final concept in this whole transaction is this. So till here it's clear, right? On 1st Jan, you filed in India, then you file the international application under Paris or PCT. Let's say you file the PCT application now. Okay, so under PCT, I've put a checklist on India also, right? I want India also to come under that. Now, something very weird happens. You'll have to again enter India only. Okay, on 25th December 2023. So on 1st December, you have gone to US. On 25th December 2023, you file a national application again in India. Okay, because for you to claim the PCT treaty, right, you'll have to file every country that you have put a checklist on that, right? So you'll technically have to enter India also because you put a tick on India also, right? So you have to file a national application in India again, and the priority date of the Indian application is also again 1st Jan 2023 because it's drawing from the PCT, which is drawing from the earliest filing date. And the original Indian application, which was filed on 1st Jan, because now the patent office has two applications, correct? When you go to the patent offices, all the documents that they have, they'll have two documents. They'll have your document which are filed on 1st Jan, and they'll have a second document also which comes to them on 25th December, right? So now the original Indian application will be deemed as withdrawn, and the new national application under the Paris or the PCT is processed. Okay, this is the end of PCT. Is it clear? I know it's very complex, but this is where patent lawyers make money, right? Any doubts? So all the
So
questions.
even
What?
the original Indian application is withdrawn, the priority date will remain 1st of Jan.
Yes, it will remain 1st Jan. It's just the document for documentation purposes. The first one is deemed as withdrawn.
Not considered. Okay,
That's it.
deemed
Okay.
as
Basically, they'll throw that in the rubbish, but the new one is there with the new priority date. Okay, that's it. Very simple. And why this is very important for you to understand is in the patent agent exam MCQs, they'll give you all these kind of questions only. You filed the PCT application on this, and then you went to Korea on December 13th, and then you came to India on January something. Okay, so next week we will solve one of the previous year papers, and I think one of the examples when you do it there, it will be very clear to you. Okay, so apart from that, we are done with the PCT procedure. Okay, since India has this buzzard of informing them first, or filing the foreign filing license first, or waiting for 6 weeks, you have to do all this rubbish. Okay, cool. So apart from that, section 8, we had skipped this last time. Last time we did section 6, section 7, and we jumped to section 9. I told you guys section 8 I'll cover next time, right? So section 8 tells that whenever you submit international applications, there are certain documents that you have to submit. Okay, so when there are international applications, as in PCT or Paris Convention, also for the same invention, as in it's the same patent family, right? The applicant has to submit a statement of all the particulars of the international application. You have to tell them everything: where you have filed the PCT, what is the search authority, what is the status of that. All the details have to be given. Cool. What is the date of filing? Everything. Then undertaking, as in like you give an affidavit stating that to keep the controller informed of the status of the international application from time to time. Whenever something happens, a preliminary examination happens, publication happens, your application has been refused in Africa or it has been granted in America, each time some development happens, you'll have to inform the controller. Okay, so you have to give an undertaking that you will keep the controller informed, because India wants to control, it wants to keep track of everything that is happening internationally. Okay, why this is so important for India is because if it is some kind of sensitive patent, let's say you filed a patent on something which is going to affect the defense of India, or some kind of atomic energy related patent, India does not want that technology to get leaked, right? This is why India wants to keep such a firm hold. Okay, like Abhijit asked, why 6 weeks? Again, 6 weeks is an arbitrary number. There's no real reason for 6 weeks, but the entire reasoning of why India expects this is because India wants to keep track of every application that is being filed by anybody residing in India. Okay, so last year the patent agent exam had this question saying that there was an American inventor. Okay, she's an American citizen and she works for NASA, an American company, and she had come to India, and in Bangalore, India, she researched, invented something, and she filed an application. Does she have to take permission to file abroad? And the answer was yes, because she was residing in India. Okay, and in this case, she was residing for like 6 months or something, so she was an Indian resident. Cool. So any Indian resident wants to make an international application, the patent office wants to know about it. So if the controller requires any additional details of your international application, the applicant has to furnish it within the prescribed time. If you don't give any details, your application will be deemed withdrawn, or if your patent has been granted, it will be revoked under section 64. Cool. I think we are at the end of the international applications. Any doubts? Cool.
Hello, Vishnu.
Go on.
I might be rushing into it, but still, if you think it is relevant to answer at this point of time,
Mhm.
suppose I'm a patent attorney in USA. I'm an Indian, but say I go and practice law in USA.
Hmm.
So this CSP, uh, will it be a third option available to me apart from these two, or
What is
will it be
CSP?
same? Collaborative search pilot. This collaborative program, which is between USA, Japan, and Korea
Hmm.
for patent examination.
Again, I'm not very clear about this. I haven't even heard of this actually. But as far as India is concerned, if you want to file an international application, it can be done only through two routes, PCT or Paris. Okay. Maybe in the
Okay.
US it might be allowed, but again, I have no idea about it with respect to India at least. Okay. Cool. Apart
All
from
right.
that, uh, that's it. Now we come to the last treaty. This is something very simple. Budapest Treaty. Again, this is administered by WIPO. So this is something very simple. Last time also, if you guys remember correctly, I told you guys when you make a biological invention, as in you've invented a new kind of microorganism or you've invented some kind of biological material, right? So it's not possible for you to describe it using mathematical formulas or even describe it using text, right? In which case, the patent office expects you to submit a sample. Okay, they want you to submit a sample of the biological material for the patent office to keep so that they'll always know what you mean, what you're trying to convey, right? What you're trying to protect. So let's say I'm filing the application in India, in Africa, in Australia, in US, in Japan, in China, right? Is it possible for me to go to each country and submit a small bit of the biological sample? No. Okay. So Budapest Treaty says that I'll have to submit the biological sample only to one place. Okay. And all the other countries are bound to recognize it. So Budapest Treaty has 86 member parties, and India is also a member. Sri Lanka is a member. Bangladesh is a member. Pakistan is a member. So if I want to file some kind of biological patent in any other country, I can submit the biological sample only to one of the places. Okay, I don't have to go to each place and submit it. So it allows the deposit of a biological sample material in a single international depository authority, IDA. Okay, where this is a place which collects the deposits in respect of all the patent applications in the member countries. Okay, so the deposit will be recognized in all countries party to the Budapest Treaty. Cool. So what all can you deposit? Can I go and deposit my underwear tomorrow? Of course not, right? So it defines that you can deposit only microorganisms because the treaty itself says Budapest Treaty on the international recognition of the deposit of microorganisms. Okay, for the purpose of patent procedure. So what is a microorganism? So the treaty does not define it. You can go through what all it includes, but in general, I've summarized it here. It includes any bacteria, fungi, any kind of genetic vector. If you can isolate a virus or any form of DNA fragment, or suppose you've utilized it to, you've created some kind of culture, as in, right, in a petri dish, they cultivate some kind of organism, and then you can look at it under a microscope. So organisms used for the expression of a gene, such as bacterial, yeast, plant, animal cell cultures, any purified nucleic acids, and any kind of naked DNA, RNA. So nothing found in nature, because if it's found in nature, what does it become? It falls under section 3, right? Discovery. Any discovery of a plant or animal under section 3J, or any just mere discovery which comes under section 3C, right? All these are not patentable. But if you have done some kind of man-made effort to isolate the DNA, that becomes a man-made microorganism, right? In which case that comes under patentable material. So all this can be deposited under the Budapest Treaty. Cool. You cannot mug it up. Don't even bother mugging it up. Have an idea of it. I think last year a question came. It just asked, like, does this have protection under the Budapest Treaty? So just read the actual.
Actually, there was a Vishnu. There was a question regarding the this microorganism or
Even I
a
remember it.
biological
Yeah.
invention, and there was a procedure. What are the steps included? So
Okay.
it
Okay.
was very tough to crack because there was no logical answer. Like you cannot get the correct answer from logic. You
Okay.
have to go through the process what is specified, and I think it would be very handy if you can discuss that particular question
We can discuss the whole paper
next
next time.
class.
Cool.
Yeah. Okay.
So
Sure.
apart from that, I have listed the procedure here. Maybe this might be the answer to that question. I don't remember it. I don't know why. Like I wrote the exam only in May, right? It's like a blank slate for me. I've forgotten everything. Cool.
No, actually, there was we just encountered it a couple of weeks back. So
Uh-huh.
it was a like, asked for particular steps involved
Cool.
when
We'll
you
solve the
are.
paper then. I'll prepare the
Okay.
solutions and we'll go through it together.
Sure, sure, sure.
Cool. Apart from that, I told you, right? The material can be deposited in any international depository authority, right? Any IDA. So India itself has 3 IDAs. Okay, not just one. India has 3. One is MCC Pune, then MTCC in Chandigarh, And then lastly, NAIMCCUP. So this was the latest. It came up in 2020 or something. Okay. So you can take your material and deposit it in any of these three. And countries like Bangladesh, Pakistan, Sri Lanka, they don't have their own IDAs. So they will come to India and deposit. Okay. So India has three. So fantastic for all of us. Apart from that, section 10. Okay. So I had not covered this. I skipped it even last time. So when we discussed what all goes into specifications, I told you that there needs to be a title, there needs to be an abstract, a detailed description of the drawings, a brief summary, object, and then I told you the claims, right? But with respect to a biological material, you have certain provisions. So whenever you submit any patent application which has a biological material, the section states that there needs to be a deposit of the material at an IDA either on or before the date of filing. So you cannot deposit it after the filing. It always has to be before. And as far as I am aware, one of the rules states that it has to be done 3 months before or something like that. Okay, so I'm not fully clear on that. I'll get back to you on that. On or before the date of filing of the patent application, with a reference to the deposit in the specifications. So in the specifications, you have to give the serial number of the deposit, where you have deposited, what is the material, all the exact details. Next, all the available characteristics of the material and all the details of the IDA deposit. Simple. And then you must disclose the source and the geographical origin of the biological material. How did you synthesize it? Because if you don't mention all of this, if you fail any of these criterias, then your patent can be opposed under section 25. One of the grounds of opposition is you not mentioning the proper source of the biological material. So you can't keep it top secret. Okay. Because why? Because once the patent application has been published, right, the access to the material is available to anyone in the general public. Anybody in the public can go to the IDA and examine your sample. Okay. So you can't lie about it, because everyone, what is the basis of patents? Where you get the monopoly in the exchange of you disclosing your entire invention. You disclosing means you have to disclose everything about your invention, even the geographical source and the way you prepared your biological material. Cool. So access to the material at the IDA only after the date of filing of the application, because even if you deposit it before, till the date of filing, it's not available for the public. Cool. That's about it. This was there in the section. Since I didn't cover it last time, I thought I'll just put it here for you guys to go through. Cool. This brings us to the end of biological materials Budapest Treaty. We come to the last big concept today, compulsory licenses. Any doubts still here? I think it's kind of simple also. This was not tough at all. Cool. So let's take a 5-minute break. I also need a small break. Go to the washroom, come back in 5 minutes. We'll start exactly at 10:20. Okay. I won't start earlier than that.
राहुल उठ जाओ।
इतनी ही चर्बी है तो क्यों नहीं आ रहा था मेरे घर में उठाने?
सत्यम भाई क्या कह रहे होंगे इस समय?
सत्यम भाई वो
अरे तुम मुझे एक बात बताओ।
हाँ भैया,
ये जो फॉर्म है सीटी जो टाइप ऑफ एप्लीकेशन है, इसमें एक ऑप्शन है मतलब पीसीटी नहीं
भैया
भाई
इको तो हो रही है यार, फिर बाद में पूछेंगे।
अब ठीक है
पूछिए भैया।
अच्छा देखो, फॉर्म 1 में टाइप ऑफ एप्लीकेशंस में ये ऑर्डिनरी कन्वेंशन एप्लीकेशन पीसीटी एनपी, तो अभी जब हमें पीसीटी एप्लीकेशन फाइल करनी है तो पहले तो हम इंडियन पेटेंट ऑफिस में ऑर्डिनरी एप्लीकेशन फाइल करेंगे, ठीक है?
जी भैया।
यस
ठीक है, जब उसके 6 वीक्स हो जाएंगे उसके बाद हम पीसीटी एप्लीकेशन फाइल करते हैं।
यस
तो अब इंडियन पेटेंट ऑफिस को भी तो बताना है कि हमने मतलब एक इंटरनेशनल एप्लीकेशन फाइल करी है, तो उनको कैसे बताएंगे? फॉर्म 1 में ही बताएंगे या मतलब किस तरह से बताएंगे उनको?
नहीं देखो
दो
तरीके
बताना पड़ेगा उसको।
या तो आप पेटेंट ऑफिस में कंट्रोलर से परमिशन ले लो, या जो भी अथॉरिटी है
परमिशन की बात करो। परमिशन नहीं ले रहे हो,
परमिशन नहीं ले रहे हो, आपने
6
सिर्फ आपने एप्लीकेशन फाइल कर दी, ऑर्डिनरी एप्लीकेशन, ठीक है? उसके बाद आप किसी भी उसमें 6 हफ्ते हो गए, उनको पता है कि आपका एक पेटेंट की एप्लीकेशन इस ये पेटेंट स्पेसिफिकेशन की एप्लीकेशन एक आपने फाइल करी है, उसके 6 वीक्स के बाद आप ऑटोमेटिकली एलिजिबल हो जाते हो। उनको देन आपको इन्फॉर्म करने की जरूरत नहीं।
ऑलरेडी वहां पे पड़ी होती है
इंटरनेशनल एप्लीकेशन
अरे एक एक करके
देखो मतलब जो मैंने पढ़ा है कि हम अगर इंटरनेशनल एप्लीकेशन दे रहे हैं ना, तो उसमें हमें किसी भी तरह इंडियन पेटेंट ऑफिस को ये बताना ही है। मतलब हम एलिजिबल तो हो रहे हैं 6 वीक्स के बाद, बट हमें 6 वीक्स के बाद भी उनको ये तो बताना ही है कि हम भाई इंटरनेशनल एप्लीकेशन फाइल करने जा रहे हैं।
यार ऐसा तो कहीं नहीं बताया विष्णु भाई ने।
मतलब मुझे ऐसा लगता है कि ऐसा है। ये अभिजीत भाई भी सुन रहे हैं क्या?
पता नहीं, शायद।
चलो आके पूछते हैं।
हाँ जी सत्यम जी।
हाँ अभिजीत भाई, आपने क्वेश्चन सुना मेरा?
नहीं नहीं, मैं मतलब वो तो ऑन
अच्छा
है, लेकिन मतलब ध्यान कहीं
देखो,
और था।
मेरा क्वेश्चन क्या है, इंटरनेशनल फाइलिंग से रिलेटेड है पीसीटी। हमने पहले एक
हाँ हाँ,
ऑर्डिनरी एप्लीकेशन फाइल कर दी इंडियन पेटेंट ऑफिस में,
ठीक है।
फिर अभी 6 वीक्स हो गए,
ठीक है।
अभी हमें इंटरनेशनल एप्लीकेशन फाइल करनी है। तो म- मतलब हम इंडियन पेटेंट ऑफिस को कैसे बताएंगे कि हम इंटरनेशनल एप्लीकेशन फाइल कर रहे हैं?
नहीं, ये भी तो डाउट है कि क्या बताना
हाँ हाँ,
अगर इम्पोर्टेंट है।
जैसे हम इंटरनेशनल एप्लीकेशन फाइल कर रहे हैं, मतलब हमने ऑर्डिनरी
हाँ जी।
एप्लीकेशन फाइल कर दी इंडियन पेटेंट ऑफिस में, 6 वीक्स के बाद अब हम पे एलिजिबिलिटी आ गई कि हम इंटरनेशनल एप्लीकेशन फाइल कर सकते हैं। तो दो
हाँ,
क्वेश्चन, क्या इंडियन पेटेंट ऑफिस को हमें ये बताना जरूरी है कि हम इंटरनेशनल एप्लीकेशन भी फाइल कर रहे हैं?
Wait, Satyam, repeat your question again from the start.
ओके, तो माय क्वेश्चन इज, we need to file an international application, okay?
Hmm.
So first of all we have filed an ordinary application in Indian patent office.
Hmm.
Then after 6 weeks we got the eligibility
Hmm.
to file a international application, right?
Yeah.
Okay, so there are two questions. So are we bound to inform Indian patent office that we are going to file an international application? First question is this.
Hmm.
And if yes, we are bound, so how we will inform the Indian Patent Office? Either it is through Form 1 because there is an option of PCT, NP and convention application in the type of applications.
Yeah.
So you inform them under Section 8, first of all, because you are bound to inform them under Section 8. And secondly, you file Form number 3. So Form 3 is undertaking for filing international
Ah,
application. This
correct, correct.
undertaking that is under Part 2, this undertaking is filed under Form 3.
Mm,
Yeah.
yes,
So
yes.
each form, what it does, you'll have to know by heart. Okay. Because see, the title it gives you is patent agent. So you'll have to know the procedure properly. All the forms, the fees, you'll have to know.
Mhm.
Okay.
That's
Form
what.
3.
So, Vishnu bhai,
Whenever a client
we
writes
need
a
not.
Vishnu
written
bhai,
request,
what about fees?
So
Have
each
you
form,
memorized? Have you memorized the fees? Because I think there is a quite a expansive table about the fee
see,
structures.
any memorizing, no, like I have a lot of jugadu techniques. So towards the end, right before the exam, if you guys want to know any faltu techniques, I can teach you. So there is a way to remember.
Dono, you can teach it in the next class.
ठीक है, I'll see. I don't want to overload you guys. If you can find your own way of learning, that's great. But I have my own method. Yeah, I'll tell you guys. I'll
No,
show you guys.
actually, with regards to the table that mentioned the, I think schedule one is the schedule in which the table is given about the fees.
Hmm.
So there's, I think, 2 page of quite an exhaustive list
Hmm.
where different amounts have been mentioned with regards to the time period,
Okay.
renewal pieces, and
After 3 or 4 years, the fees has been revised.
Hmm. But I think all of them, no, weirdly enough, it'll all fall under the multiples of 800 or 1600, and it's possible to learn it. So there'll be one question in the parent agent exam. Okay, it'll ask you how much fees has to be filed. It'll tell you that your patent application has 18 pages and 25 claims. So what is the fee that has to be paid? Okay. And when I gave the exam first time, it was a full pure tukka. I got it correct. And last time I knew the exact fees, so I got the answer. So
I think
literally,
for each extra page they ask 800 rupees. Oh, for
uh,
each extra claim they ask for
each claim
800
also, extra claim also.
and for extra page 400 rupees.
So you'll have to add and give the exact value. Okay. So if you have the brain space, learn it, because for one question, don't waste too much of energy. Only 1 mark will come. Okay. So apart from that, yeah, let's see. I'll give you guys all the tricks. Apart from that, I'll share one document today, and that document is like the Brahmastra of this exam. Okay. It's 20 pages. It's like literally just all the quick facts that you need to know. Okay. It's brilliant. I'll share it today. Just learn it off. Cool. Apart from that, can we proceed? Is my screen visible? How's my connection?
One doubt.
Go on.
So, this is in the case of Budapest Treaty.
Hmm?
Can test tube babies come under patentable convention?
No, because it goes under section 3 B, it goes under public order and morality.
Okay.
Okay. So this happened in Europe. So the case name was what is the case name? It's not coming to me right now. I'll tell you guys the case name. Okay, something Parker. Okay, Brunson, Oliver Brunson. Okay, Oliver Brunson versus European Union or something. So there he tried to get a patent on test tube babies. Exactly what Subramaniam is asking. So in that case, the court said no, since it goes against public order and morality. Because in European Union, their patent act, whatever they have, the European Patent Act, that says that any invention relating to the human body is not patentable. Okay, so even if you make any invention that is relating to any human aspect, that is not patentable in the European Union, and even in India, it will be rejected under Section 3B. Okay, because it's prejudicial to human life. That's what they'll say. So the natural question which came to my mind was that there is this technology called CRISPR-Cas9. Okay, CRISPR-Cas9 is a gene editing software. So I can just go into my body, I can edit the genes, as in I can make myself taller or remove some kind of disease or give myself some other feature. So this is a technology which is there. But to my knowledge, at least to my understanding of the Patents Act, this will also be rejected as being prejudicial to human health. So it won't be allowed a patent in India, at least. Okay. So again, we'll have to see. If you guys remember the Onco mouse case where a cancer gene was allowed, right, because it was benefiting humanity as a whole in the longer run. So in that case, maybe patent can be allowed even for CRISPR-Cas9. You could make an argument for it. Cool. Anything else?
Yeah. And one more is that can medical surgeries also can't be given any license, right? A
medical treatment, Section 3I, I for injection. No
I for
treatments
injection,
are allowed.
okay.
Yeah.
No,
Not
but then again, how is it that they try to recognize that certain doctor could do certain transplantation, so they get that recognition in that case?
It won't be patentable. It might be recognized. It's not patentable.
Not okay.
As per, I think surgery methods are also patentable if they are related to cosmetic surgeries.
Interesting. Maybe. I'm not sure about this. Again, this is like an off case, I guess. But
Right.
probably, maybe. Again,
What
as far
kind
as
of
I'm aware.
enlargement of lips, it is patentable.
What?
Nee, what kind of plastic surgery is patentable?
No, I
It's
think
like
what Satyam or whoever spoke means is what he means is anything which, see, the goal of the Patent Act is to make sure that the poor people get access to your patents, right? They don't want anything to be overpriced. But a patent does the opposite. A patent gives monopoly rights to the patent holder, right? And now, glad we discussed this because compulsory license is all about that. And what I mean to say is, when you get a patent on any kind of surgical treatment or some kind of diagnostic treatment, what happens is the common man cannot afford it. It becomes too expensive for the poor people, right? Even a government hospital cannot have it now because a private player has a patent on it. In which case, this becomes contrary to what? Public order and morality, right? It goes against the basic common sense understanding of giving the best to society, right? So it goes against the public interest, which is why any surgical treatment which can affect your human health and life cannot be patented. But like what he said, maybe cosmetic surgeries are kind of a luxury thing, right? Only rich people go for. So maybe there can be a case that you can allow patents for those. Let's move on with compulsory licenses. Okay, glad we discussed this because compulsory licenses is based exactly on this. Okay, am I completely clear, Uttam? Well, how's my connection? How's my voice?
Everything fit in fine.
Perfect. Okay, so compulsory license is a very interesting topic. Pay attention now because it's super interesting. So what does it mean when you say the word compulsory itself? What does it mean? It's compulsory. It's mandatory, right? Suppose today I told compulsory you have to attend my class. You have no other option. You have to attend it, right? So even here, it's mandatory for you to give a license. In what case? So certain general principles are given in section 83. Okay. So these are general principles which apply to all patents which are granted in India. What all are the general principles? Like I already told you, firstly, patents have to encourage other inventions. Okay, the goal is not just to give a monopoly to the patent holder. It should enable other inventions, other kinds of technological development. Apart from that, it should be conducive to social and economic welfare. You have to benefit the larger society in general, right? Society at large. You can't just benefit a few billionaires and private players. Then it should not impede protection of public health and nutrition. Okay, anything which affects the larger public health or the nutrition of people, because even agricultural products are not allowed patents, right? We have already discussed this under section 3H, horticulture, right? Even patents are not allowed on agricultural products, and patents should be granted without undue delay. Okay, so that the invention can be worked to the benefit of the public and it reaches the public market as fast as possible. Next, it does not unreasonably restrain trade or the international transfer of technology. It should not affect any other commercial activity in India or any other transfer of technology from abroad to India. Okay, anything which is vital for what? For the public interest. Next, it should be available at reasonably affordable prices to the public. You can't price your patent at 5 lakhs, which nobody can purchase, right? It should be always reasonable. Next, it should secure that inventions are worked in India on a commercial scale, because a patent was not given to you just so that you can put on your resume that you have a patent, or you can't get a patent and keep it at home. Somebody's mic is unmuted. Can you mute yourself? So, uh, what I meant was the inventions have to be always produced on an industrial scale, because capable of industrial application is also a requirement, right? It should always be produced for the larger public. Next, it should promote technological innovation, right? It cannot, the objective of a patent should not be to lock technological innovation. You cannot stop other people from inventing or innovating. Okay, so it should promote other people also to innovate. That's why you disclose your patent. Once your patent has been granted, it's available for others to see, so that they can see and improve it and get better patents, right? And lastly, it's not granted merely to enable a monopoly. You do not grant a patent just so that one person can profit. The goal is to balance public interest and private interest. If you remember that seesaw I showed you guys last time, there always needs to be a balance. Okay, so compulsory license is based on this principle. If these principles are violated, a compulsory license is granted. Okay, so let's see an example now. So before that, so there are two types of licenses. So licenses, suppose I have a patent on anything, right? I can license it to someone. Suppose I have a patent on some kind of mobile phone technology. I have the patent on 4G technology. Okay, I license it to Abhijit. Okay, Abhijit comes to me and we agree on a certain royalty. Abhijit agrees to pay me around 100 rupees for every mobile phone he sells, and we agree. I give him a voluntary license. Okay, so this is called as a voluntary license, where there is a free negotiation of terms of the license, and it's completely in the control of the patentee. I decide whether I want to give it to Abhijit, or I give it to Uttam, or I want to give it to Satyanarayan, or I want to give it to Subramaniam. It's completely in my control. Okay, let's say a compulsory license is imposed on me. Okay, the other type of license is involuntary license, where there is no free negotiation of the terms of the license, and a compulsory license is ordered by the controller on his own terms. The controller will set the terms of the license. He will decide who gets it. He will decide what is the royalty. In which case, I have no control as a patentee. Okay. So in what all cases you will think that, oh shit, like it sounds horrible, like it's going to completely take away the rights of the patent holder. But when is it ordered? Okay. So we will see an example now. So compulsory license is like this. So let's say there is a patentee, and the patentee has a patent on a bamboo copter. So the bamboo copter patent has been granted on 1st Jan 2024. And then the general public. So now what is Doraemon going to do? He's going to sell it, right? He's going to commercially work it and he's going to sell it to the public. So the public want to purchase it now, right? So Nobita's parents want to buy it now. But then Doraemon tells each bamboo copter is 1 lakh rupees. Okay. And the public, they'll be like, what the fuck? Like, we cannot afford that. 1 lakh rupees for one bamboo copter is not affordable to the common man, right? It's not reasonably affordable for a normal person. So what ends up happening is the public cannot buy it, right? So what is one of the general principles I listed under section 83? That it has to be reasonably affordable to the public, right? So now Doraemon is like, jo karna hai kar lo. So I don't want to sell it to you guys. You pay me 1 lakh or you don't want it, right? I don't want to sell it to people who don't pay me 1 lakh. And Doraemon will find rich people who will buy it, right? Of course, the billionaires, Ambani, Adani will be able to buy the bamboo copter at 1 lakh. Very simple. So now, in 2024, okay, so 1st Jan 2024, he's got the patent granted, right? Same year, two people come. So Sunyo and Jian go to Doraemon and they say, you know what, Doraemon, you give us the license for it, okay? We will give you a little bit of royalty. And what happened? Somebody raised their hand. Is my connection fine?
Yeah. Yeah. After you said that bamboo copter, if no one can buy it for 1 lakh in, okay, lost it from there.
Oh, I'm sorry. Okay. So what I said was, now that Doraemon is charging 1 lakh for the bamboo copter, the public cannot afford it, right? It is not reasonably affordable to the general public. So section 83 said what? It said that all patents have to be reasonably affordable also, right? So the general public can't afford it. But there are rich people who can afford it, right? Ambani can still buy it. Adani can still buy it. And now Mitchell Stark has got 24 crores in IPL. So even he can buy it, right? But the normal person can't. I can't buy it. So what happens is, now that the patentee has the patent, Doraemon tells, jo karna hai kar lo, I don't want to give it to all the poor people. I only want to sell it to rich people. Okay. So now two licensees come in the same year, in 2024 only. Jian and Sunyo come and they say that, you know what, Doraemon, you give us the license. We will sell the bamboo copter at a cheaper price. We will be able to manufacture it on a large scale. We'll sell it to all the people all around the world, and we'll sell it at a cheaper price, and we'll give you so much of royalty. We'll pay you around 500 rupees per bamboo copter. So Doraemon tells Bastard, no, I don't want to give you the license. Okay, it refuses the license to Jian and Sunyo, and he tells, I will not give you the license. I want to sell it on my own. Okay, so now what happens? So Jian and Sunyo have not got the license in 2024, right? So they have to wait for 3 years. They have to wait till 2027. Okay. After 3 years, Jian and Sunyo can go to the controller. Okay. And they tell the controller that, see, these are the facts of the case. There is one bastard Doraemon, and he is not selling the bamboo copter to the public. It's not available at a reasonable cost, and he is not even giving us the license. We have already put in reasonable efforts to get a voluntary license, and he has refused. And only after our reasonable efforts have been failed and 3 years have passed, and still the price has not gone down, we have come to you. So controller is like, yeah, Doraemon is violating the general principles of a patent. So he gives them the patent application and the license. He gives Jian and Sunyo the compulsory license. Okay. So what happens? Now Jian and Sunyo have the compulsory license, and now they start mass producing the bamboo copter at a cheap price. So what happens to Doraemon now? So the patentee cannot control the cost of the patent, right? Because the terms of the negotiation are completely out of the control of the patentee, because the controller has set the price now. He sets the royalty. See, Jian and Sunyo have to still pay Doraemon. Okay, they pay some royalty, but Doraemon has no say in that, because the controller sets the terms of a compulsory license. Okay, and now Jian and Sunyo are selling it at only 1,000 rupees, 10 times lesser than the price Doraemon was selling, and it is reasonably affordable to the public. Okay, so this is a compulsory license. So what are the 3 goals of a compulsory license? Firstly, it seeks to give reasonable royalty and remuneration to the patentee, so the patentee is not lost. Okay, so the patentee still gets a royalty, but it is reasonable as determined by the controller. Next, it gives a reasonable profit to the licensees also. Of course, the licensees cannot manufacture it at loss, so it assures them also a reasonable profit. And it also assures, the third thing is reasonably affordable prices to the general public, so that the public can exploit and utilize the invention. Okay, 3 things: reasonable royalty, reasonable profit, reasonably affordable prices. This is a compulsory license. Okay, so a compulsory license which is given to Jian and Sunyo, it is non-exclusive. As in, like, the controller can give the compulsory license to other people also. Okay, it's not restricted only to Jian and Sunyo. Jian and Sunyo can't say that, oh, only we have the compulsory license. The controller can choose to give it to others. So it is non-exclusive. Okay, and secondly, it is non-assignable. So Jian and Sunyo can't take the compulsory license and sell it to Digisuki now. Okay, it's non-assignable. If Digisuki wants it, he has to still go to the controller and get it now. So it is non-exclusive and non-assignable, and is granted with a predominant purpose of supply in the Indian market. So whatever is manufactured using a compulsory license has to be predominantly supplied only in the Indian market. Okay, so there is one exception for it under section 92. This is section 90. 92A talks about an exception for medicines. Okay, only for medicines an export is allowed. Otherwise, anything manufactured under a compulsory license is predominantly for the supply in the Indian market. It doesn't say all of it, but majority has to be supplied for the Indian market. Okay, any doubts in the concept? I'll be going through the provisions now. Any doubts?
Vishnu?
Ah.
So when the controller assigns this compulsory license, so is there a minimum term for the compulsory license which will be renewed, or is it perpetual?
It's a great question. It's also there in the Patents Act. So the compulsory license which is granted, firstly, it is after 3 years, right? If you guys remember, they went only in 2027, right? So it's already after 3 years after the grant. After that, in general, most of the time, the compulsory license is for the entire duration of the patent, which is the remaining 20 years. Okay, in nearly all cases, except where the controller feels that it is in public interest to not grant such a long compulsory license. Okay, so in general, it is for the remaining duration of the patent, unless the controller himself feels that it is against public interest to grant them such a long compulsory license. Great question to ask. Cool.
Could you repeat
But
that
I
question?
think it can be revoked if the conditions are met for which the compulsory license has been taken.
Right. So the first question that he asked was, he asked me to repeat it. So compulsory license, see, every license has a duration, right? Even if I license my cricket bat to...
Question asked by, okay, Abhijit, that's what I meant.
So suppose I license a cricket bat to Abhijit. Every license has a duration. I can tell for 5 years, Abhijit can sell cricket bats in my name. Okay, he can sell my bamboo copters. So once 5 years is over, the license has expired. So Abhijit asked, what is the duration of a compulsory license? So in general, the Patents Act says this in one of the provisions, that it is for the entire remaining duration of the patent. As in, let's say the patent is for 20 years. In this case, 2024 Jan was the date of the patent, right? Grant. So let's say for 20 more years, the patent is there till 2044. That means if the compulsory license is issued in 2027, it will last till the remaining duration, till the patent expires. Okay. Except in cases where the controller himself feels in public interest that he has to reduce the duration, it's always for the remaining duration. Okay. The second question that he asked, what is the question? The second question? Another question was asked, no?
No, I said that
when the conditions are not same. Okay. So in this case, I will explain that also. So what he asked was, let's say Doraemon comes later on after 2 years or 3 years and he says that, hey, I'm going to start manufacturing it at 1,000 rupees. Is it possible to revoke the compulsory license? Yes, the answer is yes. If the patentee himself proves that all the conditions which were necessary to issue the compulsory license are no more needed, then the compulsory license could be revoked, but the controller will always ensure whether the licensees are prejudiced. Okay. So that means that the controller could cancel the compulsory license, but he has to ensure that Sunyo and Jian are not prejudiced. Okay. He has to ensure that they are also looked after. Yeah. Cool. I think I mentioned it also. So certain provisions now of compulsory license. Firstly, it is after.
Vishnu,
Yeah.
I have a couple of more questions.
Go on.
Say the patentee intends to sell the patent after, say, 2.5 years. So, does the new patent holder have only 6 months to make the patent available to the public, or again the 3 year period will start? This is the first question.
It is 3 years from the grant of the patent, not from the sale. So even if your sale happens in the last 3 months or something, that's irrelevant. They see the grant.
Okay.
3 years from the date
Next
of grant.
question. Okay. Next question is, say for example, a patentee has some primitive technology. He has developed this invention, but due to the primitive manufacturing capabilities, he is not able to manufacture it at a lower cost. Whereas there is another competitor in the market who has this advanced technology through which he can manufacture this same product at a significantly lesser cost. But the patentee is making efforts to make the patent available to the public. So in that case, will the compulsory license be awarded to this competitor solely because he can manufacture it at a lesser cost and therefore it will serve the public purpose?
Cool. It's a fantastic question. The answer is there in the next slide now. And the answer is the controller will always give the benefit of doubt to the patentee. Okay. He'll always give extra time to the patentee to enable him to work the invention profitably. Okay. He'll always give him extra time. And we'll see it now. And I'll answer your question once we see it. So firstly, compulsory license is granted after 3 years of the grant of patent. So till 3 years are passed, you cannot even apply for the compulsory license. You have to wait for 3 years. 2024 means you'll have to wait till 2027. Okay. Any interested person, as in even a prior license holder, may make an application to the controller. That means that, let's say Doraemon is selling the bamboo copter. Let's say Doraemon is selling the bamboo copter for 1 lakh now. Okay. And Jian and Sunyo are actually license holders of Doraemon only. And they've been paying Doraemon 1 lakh rupees per bamboo copter that they are also selling. Okay. So the license holder, he also understands that it's not profitable for him to give that much royalty. And he also knows that he's selling it to the public at a higher cost. So the license holder, even a prior license holder, can go to the controller. So any interested person, as in the general public, as in Nobita's parents, or any person in the public, or any other manufacturer, like Abhijit said, some other manufacturer in the same industry. So any interested person, even a prior license holder, may make an application to the controller for a compulsory license after 3 years of the grant of the patent. And what are the grounds for a compulsory license? Basically, the reasonable requirements of the public are not satisfied. And what are reasonable requirements? Pretty much everything in section 83, right? Any trading or manufacturing is prejudiced, as in there's a restraint on trade, technological innovation is not available, it's not available at a reasonable cost, it's not available at a reasonably affordable price. 1 lakh is too much. See, patented invention is not worked in the territory of India. You can say that the patent is not even available for me to purchase. I want to buy this medicine, but he's not even selling it in India. So you give me a compulsory license, I'll manufacture it and sell it. Okay. So the patented invention is not worked in the territory of India. And lastly, so these are the 3 grounds. Reasonable requirements are not satisfied, not available at a reasonably affordable price, and not worked in the territory of India. Cool. In which case, if the grounds are satisfied, the controller may grant a compulsory license as he deems fit. I told you, right? The controller is the king of the Patents Act. He decides everything taking into account the following. Firstly, he'll see what kind of invention is it. So based on what Abhijit asked, will a compulsory license be granted if another person has a cheaper way to manufacture it, even though the patentee is trying his level best, right? So in this case, the controller will see a lot of factors. Firstly, he'll see what is the nature of the invention. Is it some kind of life essential to life? Is it some kind of crucial life drug, or is it some faltu printer or some kind of machine, or is it something that is going to completely revolutionize or make everything cheaper now, right? Is it some that kind of a technological innovation? And how much time has elapsed, as in how much time has the patent holder himself got to work the invention? How much time has he got to manufacture it and give it at a reasonable cost, right? So he will take into account what all efforts the patent holder himself has put in to making the invention available to the public properly. So he will consider all of this. Next, he'll see what are the measures undertaken by the patentee to work the invention. He'll see, has the patentee done his due diligence? Has he tried his level best to make the invention available at low cost? So if he has tried, the controller will give him more time, right? So the controller has this kind of discretion. Next, he will see the ability and the capacity of the applicant, as in the person who's applying for the compulsory license. See, I can't give it faltume to any beggar on the road, right? So I have to see, does he have the ability and the capacity? Suppose I give him the license. Does he have the ability to produce the invention and solve all the issues that the patent holder could not solve, right? Does he have the ability to provide the capital, to open a factory? Can he take the risk to manufacture the product? Only if all that is yes, then I can give him the license, right? And whether a reasonable attempt was made over a reasonable period to obtain the license. So I told you, right? First, Jian and Sunyo have to go to Doraemon. Before going to Doraemon and trying to negotiate a license, they cannot directly go to the controller. So the controller is trying to do what? He's trying to ensure the best interest of the patent holder. He does not want to keep the patent holder in the dark. He wants to keep him aware at all stages, give him the benefit of doubt at all points, right? So he tries to see what is the invention. Has the patent holder tried his level best? Has he done his due diligence? Then he still sees, does the license holder have the ability, which the patent holder did not have? And lastly, he sees, did the license holder even try to get a license in the first place? If yes to all of this, then the controller may grant a license as he deems fit. So in India, till date, only one compulsory license has been granted. The case name is this thing. Bayer Corp versus Natco Pharma. Okay, Bayer Corp versus Natco Pharma. So the case was about a drug for kidney cancer. Okay, so the kidney cancer drug was extremely expensive. So the Kerala High Court ordered a compulsory license to be issued. Okay, because the drug was not reasonably affordable by any person in the normal public because it was too expensive. Okay, so Natco Pharma got a compulsory license to manufacture the drug. Cool. So so this reasonable period has been defined as 6 months. So for 6 months, you should have tried to get the license properly from the person voluntarily. Only after failing which you can go to the controller. Okay, so Jian and Sunyo should have gone to Doraemon for 6 months, tried to negotiate a license. Only when the talks fail, only then they can go and get the actual compulsory license from the controller after 3 years of grant. Cool. I think we have covered everything in a very slow and clear manner. Just a few more points. So after 2 years
One
of the
thing,
grant,
Vishnu,
yeah, go on.
I think this Bayer Corp versus Natco Pharma case is the only case in India where the compulsory license was granted, or was it only the first case?
It was the only case. It was the first and the only case.
Only case, no?
Yeah. So let's see. Now that we are patent agents, we can also try and apply, right? So let's see what is the second case. So apart from that, now that the compulsory license has been granted, right? So don't you think that after some time the licensee might, who fixes the royalty in the compulsory license? The controller, right? So after 5 years, maybe the royalty is not enough. Maybe it's more expensive to manufacture the item now, right? So you want to revise the terms of the license. So what happens is, after 2 years of grant of the compulsory license, before that, after 2 years of grant of the compulsory license, the central government or any person interested may apply to the controller for revoking the patent itself for not meeting the objectives of the compulsory license. Okay, this is something little different. So what I meant was, why is the compulsory license granted? To meet the general principles, right, of Section 83. It has to be reasonably affordable. It has to promote science and technology, not restrain trade and manufacture, all this. So let's say the compulsory license has been granted. Licensee Sunyo and Jian have got the license. Okay. Even after 2 years of grant of the compulsory license, these objectives have not been met. It is still not cheap for the public, right? In which case, central government or any person interested, any person in the public may apply to the controller to revoke the patent itself, because now the patent holder is one bastard. He's not able to do it. And even the license holder is not able to deliver it. He's not able to satisfy the requirements of the public. So I will tell the controller, you please revoke the patent itself, because now when the patent does not exist, it's available to the public free of cost, right? So that's what the thing is, right, now that the public interest is not maintained by the patent holder or the licensee, now you ensure it by revoking the patent itself. So 3 years after the grant, you can apply for the compulsory license, and once the compulsory license has been granted, after 2 years, you can apply to revoke the patent. So this is form number 19, if I'm right. Okay, form number 19 is to revoke the patent, revoke the patent on non-working. Cool. So apart from that, if the controller is satisfied of the grounds that these people make, he may revoke the patent. If he still feels that the license holder or the patentee have not been able to satisfy the public interest, he may revoke the patent. Okay. And application to be decided within 1 year of the controller. Cool. So there's a time limit of 1 year which is prescribed. So controller has to decide within 1 year. Cool. And if the controller is satisfied of insufficient time to work the invention, suppose the controller feels, Arey, you've just given the license, give him some more time. He's trying his level best, right? Even the patent holder has just got it. He has bought a factory now. He has just purchased the machinery. He's got all the licenses. He's going to manufacture it. Give him some more time. So if he feels it has been insufficient time to work the invention properly, he may adjourn the application for grant of compulsory license or the revocation of the patent for a max of 12 months. So he's giving him 12 more months to enable the working of the invention. So like what Abhijit asked, if some other manufacturer is able to manufacture it cheaply, right? But I still feel that this person is still trying his level best, then I can give him a breathing space of 12 more months because I still feel it's insufficient. I can adjourn the proceedings for 12 months for him to enable him to work the invention properly. Cool. So this is the discretionary power of the controller. Yeah, any doubt?
Vishnu, just one doubt here. Suppose some other party invents a novel method or a more efficient process of producing the same product for which patent has been granted. So doesn't that particular party can apply for a process patent on that particular product?
Definitely. So he has a new patent now, right? So he will have a patent. Does that patent have an inventive step? Does his process have something new and inventive?
No, that is what I'm delving on. That in case he has a novel process and he has a patent on that particular process, but the product is not at all being licensed or it has been already patented. So he cannot manufacture that product using that novel process until he has got the compulsory or voluntary license, something like that. Isn't it a stalemate situation?
It's a very complex off case. So what Uttam is asking is, let's say I have a patent on a very particular drug, okay, some kind of thyropurine drug, okay, it's very complex. And I have the patent on the drug itself, okay. But Uttam has invented a much cheaper and faster way to manufacture it, okay. So he uses the process and he gets a process patent and he makes the drug using the process, but he can't sell that drug anymore because I have the patent on the drug itself. I think that's what Uttam's question was. So now we are in a stalemate because he has a better method to manufacture it. He has the patent on that and I have the patent on the drug itself, right? So who's going to sell what? So this will never happen in real life, but even if it happens, for some fuck all reason, the Patent Act has this provision and I've put it in the very next slide. Okay. So I'll show it to you what happens in that case. Great question. I don't know how you asked it.
I think 88 will come into play, right?
What will come into play?
Section 88 will come into play.
Exactly. So I'll tell you what it is. It's absurd beyond measure and it'll never happen. But again, somehow somebody in the Patents Act, maybe Uttam's grandfather has thought of it and put it in the act, but let's see it. So before that, just the basic procedure for the compulsory license. So the application for the compulsory license is made when? After 3 years of the grant, right? Once the application is made, that application for the compulsory license is also published in the weekly journal. So there's a weekly journal. Every Friday it's published with all the weekly patents, right? Every patent application which has crossed 18 months is published in the weekly journal. So even the compulsory license application is published in that weekly journal. And a notice is served on the patentee. Okay, the patent holder on whom the compulsory license will be forced on, he will be getting a notice. And even the license holder gets a notice. So everyone is kept in the loop. Then an opposition to the application may be made to the controller. So who will oppose the application for a compulsory license? The patentee, right? Or the other people who hold the patent. So they may file an opposition to the controller. They'll say that, what is this guy talking about? We are selling it at a reasonable cost. I am ensuring that reasonable trade is not being prejudiced. There's no restraint on trade. What's the issue? Why should you give the compulsory license? Then the controller offers both parties an opportunity to be heard and pass decision. Cool. So he hears both the parties. There is a natural principles of natural justice are followed. Cool. So if the applicant cannot work the invention without infringing on other patents held by the same patentee, controller may grant compulsory license in respect of all the patents. Okay, so this is little different from what Uttam said. Let's say I have 5 patents. Okay, and I have to give the compulsory license only for the bamboo copter to Jian and Sunyo. Okay, but Jian and Sunyo find out that I have some other patent for the propeller, and if they don't get the compulsory license on that also, it's not possible for them to make the bamboo copter, right? Because I hold multiple patents. So in that case, if the applicant Jian and Sunyo cannot work the invention without infringing on other patents held by the same patentee, controller may grant compulsory license in respect of all the patents. Okay, so controller has the power to give compulsory license in respect of many patents. Okay, just to be able to work that invention properly, he can grant a license in respect of other patents also, if it's held by the same patentee. Cool. Licensee, yeah, this is up till here, it's done. Apart from that, let's say the compulsory license has been granted, royalty has been fixed. After some time, I'll realize that the royalty is not sufficient, right? So in that case, I can file an application to revise the terms of the license. This is form number 20, I think, right? So form number 20 is for revising the terms of a license. So licensee may apply to revise the terms and conditions of the compulsory license after 1 year of grant of license. So 3 years after grant, I can file the application for the compulsory license. 2 years after the grant of the compulsory license, I can file for revocation of the patent. And forgetting that, 1 year after the grant of the compulsory license, I can apply to revise the terms of the patent, revise the terms of the compulsory license. Cool. After proving that the original terms and conditions were more onerous, that's the word used in the act. That means more difficult to maintain than expected, as in the royalty is not sufficient, the profit is not sufficient for me to manufacture the product at a reasonable profit. Because I told you, right, the licensee's reasonable profit also has to be ensured, and the licensee is unable to work the invention except at a loss. It's not profitable for me to sell the product at all. Cool. So, and this revising, this application to revise the terms is allowed only once. You cannot keep filing it every year. It's allowed only once. So use it wisely and carefully. Now coming to what Uttam asked, something very obscure, and surprisingly it matches the scenario in the Patents Act, where let's say I have the patent on a product, okay, and Uttam has a patent on a process or another related product, but it's not possible for Uttam to manufacture or sell his product or do anything with it without getting a license from me. Okay, so he needs a license of my product now, right, just to work his product efficiently. Okay, so let's say patentee 1 is there, patent 1. So Doraemon has the patent on bamboo copters. Okay, next patentee 2 has patent number 2, which is the patent on anywhere door. Okay, so for some reason Digisuki is unable to utilize his anywhere door without utilizing certain components of the bamboo copter. Okay, so he needs certain aspects of patent 1. Okay, so in this case, a compulsory license will be granted to Dekisuki just to enable him to efficiently utilize his invention, similar to what Uttam asked. So in this case also, what he asked, he said he has a process on making a drug. In that case, the compulsory license of my drug itself will be granted to Uttam, okay, so that he can efficiently utilize his process patent in 2 cases. Patentee 2, as in Dekisugi, can obtain a compulsory license from patentee 1 in order to efficiently work his invention, which is patent 2, if 2 conditions have to be met. If patentee 2 also grants license of his invention to patentee 1, if Doraemon wants, on reasonable terms. So if he wants this license for him to efficiently work his invention, he should also be giving the license of anywhere door to Doraemon on reasonable terms. And secondly, patentee 2's invention should have made a substantial contribution to the development of commercial and industrial activities in India. So it can't be some altu-faltu invention. It has to be something significant, because compulsory license can be granted only in exceptional circumstances. In India, it's also only once it has been granted, right? So in this case, if patentee 2 can prove that his invention is substantial and it is going to contribute to the development of India's trade and development, and he is willing to license his own invention also to Doraemon, then patent 1's invention will be given to license will be given to patentee 2, okay, for him to enable him to efficiently work his invention. I think this pretty much covers what Uttam asked. Am I right?
Exactly. Just one rejoinder to this. Does these 2 conditions have to be simultaneously satisfied, or
Simultaneously.
either? Okay.
It is an and. I forgot to put that. Yes, it has to be both have to be satisfied. Cool. So let me tell you guys one thing. The Patents Act is very boring and long. If you guys have read it, I have put it in a very crisp and fun way here. But I still encourage you to go and read it, because my PPT does not cover every clause. It's not possible for me to put every clause. Okay. But I've covered pretty much the general concepts of all of it. And I've simplified it in my own words. Okay. Apart from that, the last concept, I think, in compulsory license, So these are the last two concepts. Okay. So don't you think if there is a national emergency, COVID has struck, or some earthquake happens, or some natural disaster, let's say floods have happened in Chennai, but I have a license, I have the patent on some kind of super fast motorboat. Okay, very cheap and fast motorboats. So to counteract the effects of the natural disaster, the government can forcibly issue a compulsory license. Okay. So in case of a national emergency or extreme urgency or public non-commercial use, I'm not fully sure what this means. If the central government is satisfied that it is necessary to grant a compulsory license, it may declare by notification in the official gazette. So in the official gazette, which is the official magazine of the Indian government, it has to declare, it has to put a notification saying that a compulsory license is being granted in respect of Vishnu's motorboats to solve the flood situation in Madras. Okay. So once the government gives the notification, who is the license given to, right? It has to be given to a licensee, right? So in this case, once the notification has come in the official gazette, other licensee holders will apply. So upon application by any person interested, the controller shall grant the compulsory license to that license, the person who has applied for the compulsory license. Okay. And when he is granting this compulsory license, it has to secure the lowest prices to the public while ensuring a reasonable advantage to the patentees. As in, I will still be getting some royalty. Okay. But the goal is what? It's a national emergency, right? So your goal is to give it at the lowest possible price for the public. Public interest is above all in case of some kind of national emergency. Okay. Central government decides, done, compulsory license granted. Cool. So the last thing is section 92A. It has been added by amendment, I think quite recently also. So what did I say? Every material or product which is manufactured under compulsory license has to be predominantly for the supply in the Indian market, right? So in what cases can you export it? When it is a pharmaceutical product, okay? And it is allowed only under the TRIPS agreement. If you guys are curious, Article 29 and 30. So what that says is export is allowed to any country having insufficient or no manufacturing capacity in pharmaceuticals to address public health problems. Let's say some country in Africa has no manufacturing capacity to manufacture any drugs for COVID or for the SARS virus, right? But India is like the drugstore of the world. India has so many factories, right? So in this case, export is allowed to any country having insufficient or no manufacturing capacity in only medical products, pharmaceuticals, to address public health issues. Okay. And in this case, two conditions have to be met. Firstly, provided that the country has already granted compulsory license to the product. In that country, that country, as in Nigeria or Zambia or Zimbabwe, should have granted compulsory license to the product, or it should have allowed the import from India by notification. In their official gazette, they should have released an official notification saying that we are taking this licensed product from India, we are taking the import of these pharmaceutical products. If they officially declare it as a diplomatic act, then India is free to grant a compulsory license for export. Okay. And in this case, all the products which are manufactured, all these pharmaceuticals which are manufactured to supply to this country have to be solely exported only to that country. Okay. License granted solely for manufacture and export to that country. I can't manufacture it and then sell it to Indian consumers then. Okay. So if the export license is granted, then it has to be solely only for the export and only to these countries which have no manufacturing capacity. Okay. If you are curious, Article 29, Article 30, 31 and 31 bis of TRIPS agreement talk about this only. Cool. Any other doubts? I think we're done with compulsory license. Any doubts? I think I've done it quite comprehensively also. So pretty much done. Last 10 minutes left. Parent on addition is a very small thing. Yeah. Any doubt?
Vishnu, does section 94 is required there? Termination of compulsory.
So 93 talks about
94, I think, termination of
the compulsory license, right? So I felt it was not needed to put it, because what it says is, if the terms necessitating the need for the compulsory license no longer exist, then in that case, the patentee or the applicant of the patent may apply to the controller to get the compulsory license terminated. So this is form number 21. When you submit form number 21, the compulsory license can be terminated. If you can prove that, oh, the national emergency no longer exists, right? Or this country has suddenly no need of this public health concern now. Or suppose you can prove that you yourself can manufacture it now at a reasonable advantage to the public, then the compulsory license could be terminated. Okay. So the reason I don't cover all this is it's not truly relevant, because India itself has granted one compulsory license, right? So we truly don't know how these things work. And all these are just conditions that you can imagine with Dekisuki and Doraemon and all that. It's not something that is relevant practically.
Okay. And this confounding term, public non-commercial use, Did you
I did try
got any
to
hold of
understand it. I was trying to read about it, but to my understanding, what I feel is commercial use is what? For profit, right? When you're selling something with a businessman's mindset, right? But when you're doing something as a social service, that would be a non-commercial use. Let's say I've invented a thing that will help visually disadvantaged people to see, right? Some kind of new kind of lens which will allow blind people to navigate. So if the government wants to distribute it, it's not doing it for a profit purpose, right? It's doing it for social service. So my understanding is that would be public non-commercial use. What do you think?
I think pretty close.
So I didn't want to explain it because I myself am not clear. I don't want to explain some things I'm not clear about. So whatever I've told you now, I'm 100% sure it is correct. Okay. So apart from that, we are done with today's meet. Pretty much we have only 5 minutes left, and that's the last thing today: patent of addition. Okay. So patent of addition is something very simple. So let's say I've invented a massage chair 1.0, and I've filed the application on 1st Jan 2010. Okay. That means my priority date is 1st Jan 2010, right? And let's say the patent was granted after like 2 years. So on 1st Jan 2012, my patent has been granted, but my protection is from 1st Jan only, right? So that means my patent is for how long? 20 years from the priority date. That means patent is valid till 1st Jan 2030, right? 20 years. Very simple. Now, let's say I'm continuously innovating, right? I'm in the chair business, so I'm continuously innovating, and I come up with massage chair 2.0. Okay, so this has certain modifications. It has a new vibration sensor, some new LED device, and it has some kind of haptic feedback system. It measures my heartbeat and it improves the massage. This thing. Okay, so now what happens is it's a modification, right? It's an improvement for an existing invention. Okay, but the thing is, do you think I can get a separate patent on this? It's not. There's no great inventive step to this, right? It is novel. Definitely there is novelty, but there is no inventive step here, right? It's only a small improvement on the old massage chair. I've added a few new components. Let's say my mobile phone has 4 cameras. I add some thermal sensor and add a fifth camera. So there's no inventive step, right? But there is an improvement. There is a modification. So I might not get an actual patent, but I can get a patent of addition. Okay. So in this case, I developed this in 2020 and I filed the application on 1st Jan 2020, 10 years after this. Okay. Then the patent is granted as a patent of addition. Okay. That means, is my protection till 2040 now? No, my protection is valid only till 2030. Okay. Since it is a modification of an existing patent, my patent duration does not get extended. This will remain the same, because what a lot of companies used to do was something called as evergreening. Okay. So what are evergreen trees in geography? I think you guys will hear that the trees are always green, right? So what companies used to do was they used to evergreen their patents. So once 19 years are over,
Monsanto cases and all that.
we'll discuss Monsanto later, but before that, so what evergreening means is, suppose I get a patent on something for 20 years. In the 19th year, I'll make a small modification, and then I'll ask for 20 more years of protection. And then again, after 19 years, I'll take again 20 more years of protection. Novartis versus Union of India. So there it was a cancer drug. And in that, they did some kind of modification, and they said that, oh, there is a new efficiency. We have a new drug. Give us a patent. And India struck it down under Section 3D, D for drugs. Right? India said, unless there is therapeutic efficacy, you cannot evergreen your drugs or medicines. Okay. So to prevent evergreening from happening, and to make sure that the public patent, once it is expired, it reaches the public, so that companies cannot hold on to their monopolies, patent on addition was brought. Okay. So now, even if you make any improvement or some kind of addition, some kind of faltu modification just to increase your patent duration, it doesn't happen. The duration remains the old duration. Okay. Apart from that, two things have to happen. Firstly, the applicant for the patent of addition has to be the same. Okay. Remember that I'm talking about applicant and not inventor. Okay. Let's say a company such as Honda is the applicant for a new bike engine. Okay. Now, the inventor for that would have left Honda by the time the new engine comes out. Okay, so new inventors make the new engine. So in that case also, since the applicant is the same, since Honda Motorcycle Company is the applicant, patent of addition is allowed. But different applicants it's not allowed. Let's say Uttam invents a new massage chair. I come up with the massage chair modification. I can never get a patent of addition. My invention will be struck out as lacking inventive step. It will be granted only to Uttam because he is the same applicant. Okay, very simple. Coming back to what Uttam asked about Monsanto, as far as I'm aware, Monsanto case, Monsanto has got into a lot of trouble. I'm not sure about the patent case you're talking about, but in general, the patent case that we study under Padma ma'am, it's about a patent on the genetically modified cotton. So I'm sure you're not talking about that one, right?
No, not that.
Okay, so I'm not sure about the case then, because these companies have a lot of patent litigation. Okay, so I'm not aware of the one he's talking about. So patent of addition is very clear. So just a few concepts from the Act. I've taken a few of the provisions which are important from section 54, 55, and 56. Just few provisions. Any application for improvements or modifications made to an existing patent. So it's not something that's huge, something new. Okay, just slight improvements or modifications. The applicant of the patent of addition should be the same as the. What happened? Somebody's raising the hand. Is my voice clear? Did I get disconnected?
No, your voice is clear, but I have one question.
Cool. Wait. Just 1 second. I'm almost done. We'll discuss right after this. So
Okay.
the applicant of the patent of addition should be the same as the main patent applicant. Like I told you, if Honda has filed the first patent, Honda only has to file the next one. If Uttam has filed the first patent, Uttam has to file the next one. New applicant cannot come in. But the inventors of the patent of addition may differ from the inventors of the main patent application, provided the inventors assign the invention to the applicant. Assignment is where I transfer the rights of the invention to the applicant. So when you sign a contract, let's say you join Bajaj Motors as a IP lawyer or as an inventor, when you join itself in your contract of employment, all the inventions that you create while your term of employment subsists, all of them will be automatically assigned to Bajaj. So once you assign it, they are the applicants. Okay. So inventors can be different, applicant has to be the same. The term of the patent of addition is equal to the term of the main patent. So it prevents evergreening. Okay. So why I'm telling you these terms is it won't come in the exam, but these they ask you in the interview. Okay. So just keep a note of these kind of terms, evergreening, stuff like that. If the main patent is revoked, let's say that the first massage chair, somehow this first massage chair has been revoked. Okay. So what happens to massage chair 2.0? This patent of addition also gets automatically revoked, or can it exist independently? Okay. So in this case, it's a little complicated. So if the main patent is revoked, the patent of addition may become an independent patent for the remainder of the term of the main patent. Okay. So this patent of addition has a priority date of what? The old priority date only. So even if this is revoked, if this massage chair has something inventive on its own, if this chair can stand on its own as a separate patent, as a standalone patent, then this patent of addition will be allowed to subsist as an individual patent even after this thing has been revoked. Okay, so that's what it means. If the main patent is revoked, the patent of addition may become, if the patent of addition has its own inventive step, has its own novelty, if on its own it can remain as a patent, it may become an independent patent for the remainder of the term of the main patent. Okay, so the priority date is not new. It's still the old
Vishnu,
priority date. Wait, I'll take it after this. And lastly, whenever you get a patent of addition, I told you, right, every patent, a renewal fees has to be paid. Now that the patent duration is 20 years, right, every year you have to pay a certain renewal fees. So for the first 2 years, there's no renewal fees. After that, third year, you have to pay like 1,000 rupees. Fourth year, 2,000 rupees. Fifth year, sixth year, seventh year, it's the same, around 5,000. And after that, the 15th year, 16th year, and all that. So it increases. Towards the 19th and 20th, it becomes like 50,000, 60,000, and all that, right? So when you get a patent of addition, no renewal fees is paid. Okay, you pay the renewal fee only on the original patent, not on the patent of addition, right? Because it's pretty much drawing the same priority date. Okay, so what I'm saying is no renewal fees is payable for a patent of addition unless due to some reason the main patent is revoked and it becomes independent after the main patent is revoked. Because once it becomes an independent patent, it's a standalone patent, right? Now you have to start paying the renewal fees for it. And the last two terms, and yeah, the only if the controller allows, it becomes an independent patent. Okay, only if he's satisfied there is an inventive step, it is a standalone patent, it's allowed. Okay, last two concepts and I'll take doubts, we're done. So patent of addition must be filed on or after the filing of the main invention. I can't file the advanced massage chair first and then go for the main massage chair. It always has to be with it or after it. Okay, and patent of addition need not have an inventive step with respect to the main invention. Like I told you, it can only be a slight modification. Okay, if it has an inventive step, well and good. That means even if the main invention is revoked, your patent of addition can still become a standalone patent. Cool, we're done. Thank you so much. Any doubts?
Rahul, you can go first.
Yeah, go on. Thank you. Vishnu, I think on 2008 or 7, in your in TVS company, there was a bike named TVS Centura. TVS launches the bike, and they were claiming that it is a very fuel efficient bike. It was giving around 60 kmpl mileage. But after I think few months or after 1 year, on the same bike, they have done some modification. Like if we will go on a 40 on a its speed of 40 or below 40, it will stop consuming the petrol. I think, or it will take a very less petrol. So it will be fall under the patent of addition, or it will be a new patent.
It again depends. If this invention that they made, does it have a separate inventive concept? See, even patent of addition, who claims it? The inventor himself, the applicant only claims that this is a patent of addition. Nobody else will come and tell. So if TVS themselves feel that, oh, it's not worthy of a separate patent, there is no inventive concept in it, then they won't go for a separate patent. They themselves will say it's a patent of addition. But if they feel that it is something separate, why will you file a patent of addition? Because your priority date is getting pulled back, right? As in, now let's say I've invented this new massage chair in 2020, okay, and there is a huge inventive concept, it's much better than this one. Then if I file it as a patent of addition, my priority date becomes this priority date, so my duration is still the same, it's not increased. But so why will I do that? I'll file it as a separate patent. Now my duration increases from 1st Jan 2020, it becomes 1st Jan 2040 now. So no applicant will file a patent of addition for no reason. Like, they'll file it only when they feel there is no inventive concept. Cool.
Okay.
So I don't know about the Centurion bike. If it depends on what TVS feel. If TVS feel there is an inventive concept, they might have gone for a separate patent itself.
Today go and search TVS Centura.
I'll go through it definitely.
Actually, Vishnu, my question is slightly related to what Rahul has just asked. Like, suppose you are saying in the second last point that patent of addition may become an independent patent. This slide only. May become an independent patent for the remainder of the term of the main patent. Now, as far as I have studied the points that you have mentioned under the slide, that this patent of addition in a way owes its existence to the main patent. Am I correct?
Yes.
And if certain inventive step is there, a person would be going for a new patent itself rather than going for a patent of addition. So what scenario can you just illustrate, and maybe an example or somewhat that a main patent is revoked but the patent of addition becomes independent for the remainder of the
So I have a very interesting example for you on this. So whenever a company files a patent on something, like Honda files a patent on a new kind of brake, okay, braking system. So every company tries to broaden the boundary of its patent, okay. It'll never try only to protect what the patent says. It'll try to protect everything related to it, okay. So whenever a company files a patent on a brake, they will file patent applications on every related modification of that brake, okay. So it'll be a brake with a hydraulic fluid, a brake with a slight modification, a brake with a slight adjustment of the lever, a brake with a plastic material, a brake with a polymer material. So they'll file 8 applications on the same invention. Okay. So why they do this is they'll never utilize the other modifications. Okay. They want only the one with the proper lever made of plastic, which is placed with a hydraulic fluid. Okay. They'll never utilize the other inventions. Even though they might have some kind of inventive step, they're not commercially valuable to the company. Okay. So I don't want to pay any renewal fees on it. I don't want to waste time pursuing that invention, defending it, all that. So the only reason I file it is just to stop TVS or Bajaj or some other company from even coming close to my invention. So to increase the protection of my brake, I'm filing patents on all the other relations also to that brake. Okay.
To broaden the scope, basically.
So in this case, even though there is an inventive concept in that patent is not valuable for me. So I don't want to waste my money on filing, processing, and then filing renewal fees on that. So I'll file it as a patent on addition. Okay. In this case, even if my main patent fails, for some reason, my original brake was being revoked by the controller, then my other patents which are related to it, which were filed as a patent on addition, but still have an inventive step, they will still survive independently. And somehow Bajaj can still utilize them now because they survive independently as individual patents now. Clear?
Actually, it's clear, but if it's not commercially viable for a company, why would they, in the second place, go to that particular?
So it's not commercially viable. You think that these companies have crores and crores of rupees, but the thing is, they have thousands and thousands of patents also, right? So Honda itself has, like IBM has a portfolio of around 10,000 patents, right? So if you add the maintenance, prosecution, litigation cost of their entire patent portfolio, it runs into billions of dollars. Not even kidding. So in that case, you deciding to file altu-faltu patents for every invention, it's going to end up crashing the company. It's going to end up pinching the company's wallet, right? So in these kind of cases, these are financial decisions for the company.
Okay, so they are more over a tactical move rather than
it's a strategic move. So So in this case, let's say this massage chair has an inventive concept to it only. Okay, let's say it has some kind of advancement, but I realize that I don't want to really defend it. It's not really valuable to me. This first massage chair is my real market. So why waste time filing this as a separate patent? I still file it as a patent of addition. So now there's no headache for me. It's just there.
Got it.
And it's stopping
Okay,
others
okay.
from also coming close to my invention. Right? Can you see?
Understood.
Can you feel the boundary of your patent growing now? You're able to defend a larger area.
Understood.
That's it. It's again an off case. Okay, so all these off cases you guys are great at fishing out. So good for a lawyer, but again, good for an academic exercise, right? Discussing all this. So yeah, any
And
other
I
question?
think you deserve more than Kit Kat.
Oh,
I
no
think
doubt.
probably silk or something other than.
Oh no. Kit Kat is more than enough because I'm collecting Kit Kat from everyone, right? So it becomes a large number now. So cool. So apart from that, any other questions from anything today? So I'll stop the recording and then we can discuss some college gossip.